we would have also requested an extract from the minutes of November 12th,
Yes.
which may help us in terms of part of the deliberations yesterday. So
Yes.
we want to record those two submissions for the purpose of the minutes. Thanks.
Yes, thank you so much. Ms. McClarty? Ms. McClarty?
Yes.
Yes. So that's noted. How you want me to proceed from here? Just go straight to the presentations?
Yes, Minister.
All right, thank you so much. All right, so Ms. Grant? Ms. Grant, you're on center stage again.
I'm here, Minister.
You're looking great. You're looking great.
I tried.
All right, thank you. Thank you.
Okay, so Minister, that means we're going to get back to those two things before we end, or are we going to address them now in relation to the two things that Senator Gale mentioned?
Well, Miss Mark, guide us here.
Yes,
What would you want us to do? Go to those two things or continue, and then we can treat with them after.
I'm not sure what Senator Gale.
Can I suggest,
Yeah,
Minister?
Yes.
Can I suggest, because the policy would be something for us to go through or doing our own time and review it. It would also inform as to what can be taken out of the policy to inform the code of practice or code of guidelines that we intend to pursue. With respect to the minutes,
so
I believe we can get back to that at a later date when we're going to inform ourselves in relation to that clause, that particular clause that was referenced, which I believe we have also put on hold.
Yes. So then we will proceed at this point.
Yes, that is correct, Minister.
Yeah. Okay, so Ms. Grant, over to you. Thank you.
Okay, thank you, Minister. Afternoon, everyone. Okay, so that means we are at clause 8 of the bill, and that clause deals with sexual harassment at an institution. In Matrix 1, there were no useful suggestions. In Matrix 2, the proposal was made by JFJ to expand this part to address sexual harassment between or among individuals enrolled in an institution as defined in the bill. PSOJ noted that the act is too narrow in relation to this particular clause, dealing mostly with institutions, workplaces, and briefly with landlord and tenant relationships. So the proposal they made was for the scope to be unlimited, with emphasis placed on specific settings, namely workplaces, institutions, tenancy, churches, clubs and associations, sporting activities, vendors, receipts of goods and services, for those to be considered and to be included in the definition to be included as institutions. And they also proposed, similar to what we were discussing yesterday, that a provision be inserted to protect workers from sexual harassment by clients or persons who are served by businesses, and to protect clients of private sector businesses from sexual harassment by workers. And they noted that as it is now, the bill doesn't make consideration for that. And those were the only suggestions in relation to clause 8.
Can we move on, or you have any comments in relation to clause 8? I take silence, meaning that we will move on.
No, just a point of clarification, Minister. So it was PSOJ, right, Ms. Grant?
In terms of what?
PSOJ.
In terms of the submission in relation to expanding the institutions.
Yes, Senator.
Yes.
Right. So in dealing with that, in looking at the definition for institutions at A, it made reference to a school, college, university, and other places of learning or training. Now, in my mind, that is referencing treating with institutions in an expanded way. Where I think we, the bill, and I don't know it's defined, but in terms of the objective of the bill is seeking to treat with protection of those in the tenancy, in rental. So I don't know if there's a suggestion that we somehow carve out a specific provision that covers how you treat with the landlord tenancy situation, which again would have been referenced by the Rent Assessment Board in their submissions. But I believe in terms of what the definition for as it relates to institutions, it already covers it.
I would tend to agree with you, Senator, but I think in terms of tenancy, we may need to outline in a more specific way that area, those aspects of tenancy.
Right.
Yes. Any other comment? All right, so I think let me just check to see if there are any comments here. All right, so we can move on, Ms. Grant.
So we're leaving that clause as it is then, it's fine. That's what we are saying, that's what we have decided.
Senator Gale.
Yes.
Right, do you want to propose though in relation to tenancy and the landlord-tenant situation that we look at how we can provide some kind of more details in relation to that aspect of, maybe expanding that and detailing some kind of framework for that?
Well, I would leave that for the technical team if they can so apply any particular provision that would satisfy those requirements.
All right, so that is what we're recommending. We're asking the technical team to do that. All right, so we go on to clause 9.
Which would take us into the tenancy. So since it has already been raised, Minister, I will just labor on what the Rent Assessment Board said. And they are asking, well, two things. Before I go to the Rent Assessment Board, just to indicate, even though we're going to come back to it as it relates to the definition section, that one of the suggestions that was made, I think by IJCHR, I think, was that the landlord tenant be defined in the definition section, and the terms such as lessor and lessee, that those be defined in the definition section, which we agreed that we would come back to, but just for us to note as we go through. So the Rent Assessment Board, they propose that section 9 is expanded to include the following: that sexual favor should not be suggested or requested in lieu of rent, bills, or repairs to the property. Landlords should not utilize technological instruments such as a camera to spy on their tenants or invade their privacy. A landlord should not seek or a tenant offer sexual favors for the continuation of a tenancy agreement. A landlord who may have personal information, relationship status, financial status, etc., about a tenant should not use the knowledge that he or she has to exploit the tenant for sexual favors. Where landlords have keys, that they don't use it as an opportunity to enter the dwelling. Come back to that. Landlords should not exploit a tenant's vulnerability, whether loss of employment, loss of spouse, etc., for sexual favors, and that special provisions be made for children in residential accommodation for complaints to be made on their behalf. That was the those were the notable suggestions made in relation to clause 9.
Do we have any comments here? And Ms. Mark, if you could just
a quick question, Chair. Not
Yeah.
major. Would a boarder qualify as a tenant? It is just, you know, sometimes persons take, especially students, maybe from out of town, and there's an arrangement made between parents or, you know, longtime friends or something to that effect. And there may or may not be a formal payment agreement, etc., etc. And that person probably would be defined as more of a boarder, so to speak. I'm not sure if the definition, if we would have that person in mind.
Well, I don't know if the definition would cover that person, but that person is certainly boarding and paying for the accommodation. We could be advised here from the Ms. Grant or from the technical.
I see Mrs. Seeley Brown and Solgen both have their hands up, Minister.
Okay, please go ahead. Seeley Brown?
Thank you, Chair. That was I just wanted to elaborate on the point made by Senator Longmore that the clause 9.2 is crafted in that way to include scenarios which she would have suggested, which may not necessarily be in your landlord and tenant relationship. So I'm thinking that the wider the language is, the better. It would include things that would not be included in a landlord and tenant agreement. I don't think it is necessary, even if we want to expand what should not happen in a relationship where somebody is providing accommodation. I don't think it is necessary to just restrict it to a landlord and tenant agreement.
All right, thank you. And who else wanted to make a comment? I'm sorry. Thank you, Mrs. Seeley Brown. Ms. Grant? I can't see the hands that are up, but someone else wanted to make a comment?
The Solicitor General, your mic
Marlene Aldred, Minister.
Solicitor General, please go ahead.
Yes. So I was making that same point and indicating that it had been considered and the language was decided to be deliberately wide to deal with accommodation that is wider than just a tenancy arrangement. And that was deliberately done. If you go back and narrow it to a tenancy arrangement, you will now exclude a number of other type of arrangement where you have accommodation being provided, but it's not a tenancy arrangement. So that was done deliberately. I just wanted though to ask about, just to confirm the decision for clause 8. Is it that we are leaving that clause as is? I wasn't clear on what the technical team was to do and if it related to clause 8 or if it was in relation to clause 9. So I just wanted some clarification, please.
Well, the team would have to guide us if what we are asking for should relate to 9 or 8. But what we are saying is that there should be for tenants, for tenancy. And I think the Rent Assessment Board actually outlined some of those concerns that we really need to expand. Am I right, Senator Gale?
I was just trying to jog my memory in relation to clause 8, which is speaking to institution.
Mm-hmm.
Might I then maybe assist you,
yes,
Senator?
Ms. Grant.
Yeah.
I believe what we had agreed, Solicitor General, is that the clause 8 would remain as is. That as it is now, it's quite expansive in language, and so we wouldn't need to change it.
So then the changes would relate to clause 9.
Right, and so the changes, they change to clause 9 now. So I agree with Solgen in terms of the use of the word accommodation being broad and wide enough to cover any specific. The only thing that I'm needing clarity on is, so it speaks to a person shall not in the course of providing or offering to provide, whether in principle or agent, accommodation to another person, and A, B, C, D. Now there was a reference by the rental assessment board around the setting of cameras or device within the accommodation to spy on. How would we treat with that?
Yes, Solicitor General or Ms. Grant, you want to respond to that, please?
Because that in my mind would be, you know, some sort of an invasion in privacy.
I'm wondering though, Senator Gale, if it necessitates a specific mention, and I say so because something like that would, to my mind, constitute a breach of a quiet enjoyment that a tenant is supposed to have. So, I mean, I don't know if it should be specifically included as opposed to just leaving the section as it is, but I'll be guided by Mrs. Seeley Brown. I see her hand is up.
Thank you. Mrs. Seeley Brown, please go ahead.
Yes, Chair. Just to say that I have seen those provisions most oftentimes in sexual offences legislation or in cybercrimes legislation, which creates a serious criminal offence. So I don't think that the sexual harassment bill will be the place to put something like that. Even if you want to reference it, if you would amend other legislation for that purpose. But I think that needs to be in either our cybercrimes legislation, or as I said, you have seen it sometimes in sexual offences legislation, an offence of voyeurism. So I'm not sure that here is the scheme would accommodate something like that. I think it's necessary, but maybe we may have to do an amendment to another piece of legislation to deal with that issue.
Right, that's what I was asking.
Usually a criminal offence, yes.
Yeah, that's what I was asking Mrs. Seeley Brown, if our existing, those other well, we're dealing with, I believe we're going to be dealing with cybercrime later on.
Yes.
So maybe we need to consider in treating with cybercrime, determine if there's an inclusion, a specific inclusion in cybercrime that would be dealing with that.
And also an amendment to the sexual offences.
And also an amendment to the sexual offences. Because Minister and colleagues, whilst the appreciation is there that there is a specific concern, sometimes we might not need to expand the scope of this legislation where we can put in the requisite application and allow for other legislation to treat with those connected matters.
Okay, do we have any further comment on this?
Just to say, Chair, that I'm in agreement, because we have to remember that those offenses we would want to carry the weight of justice that they warrant. So, you know, the sexual harassment is more of a civil offense. So, the sex that would be covered by sexual offenses, and that is the gravity of such an offense. So I wouldn't want us to muddle the waters.
Okay, thank you, Senator. Thank you, Senator Longmore.
See, Mrs. Seeley Brown has her hand up again, and the Solicitor General, Minister.
No, I'm sorry, that was an error. I should have removed it.
All right, SG, could you go ahead?
So I'm just suggesting that if the committee feels strongly about the issue, which I think you do, you could actually include in your report that the issue came up. It's not really within the remit of this piece of legislation that you are reviewing. However, you're making a strong recommendation to Parliament that this matter needs to be addressed with urgency. And you could perhaps I mean, Mrs. McCarthy can advise, but you could perhaps even indicate which legislation you think should be considered for amendment, which I think right now would be the Sexual Offences Act and perhaps the Cybercrimes Act. So that is something you could actually include in your report.
Thank you, SG. We would want it included in our report, and we would want to speak to amendment to the 2 pieces of legislation. Members, are you in agreement?
Total agreement, Minister.
Yes, Chair. Yes, Chair.
Okay, great. Thank you. Ms. Grant?
Yes, Minister. So we leave clause 9.
Ms. Grant, may I?
Yeah. Yes, Mrs. Celia Brown? Yeah.
Just before, because I realize we're moving on to part 4, Chair. And I don't know if it's a good time to ask the committee whether or not we are coming back. There's some issues that were raised yesterday in relation to clause 7, which are very important and would affect the scheme and the entire policy of the bill. Are we going to come back to have a discussion on that at a later date?
That is what we had agreed on. Am I right, Ms. McCarthy or Ms. Grant?
All right, 5169. All right. Okay.
Yes, Minister.
Yes.
Okay. Okay.
Yes. We will come back to those matters. That is in relation to clause 7.
Thank you, Chair.
I believe we also made reference to clause 5.
And 6.
What is immediate and appropriate for us to determine those?
Mm-hmm. All right, so we will come back to clause 5, clause 7. Right, Senator?
Yes, Chair.
All right. So, Ms. Grant, would you continue now, please?
Yes, Chair. So that takes us to clause 10, which is the designation of authorized officer. That's part 4. So these are the suggestions that were made. IJCHR, which is the Jamaica Commission of Human Rights, Independent Jamaican Commission of Human Rights. These were the suggestions that they made. They said that in 10, the minister is authorized to designate certain field officers in the Bureau of Gender Affairs as authorized officers to act as investigators of complaints and for the tribunal. The proposal is to include rules to guide these authorized officers as well as to inform the complainants and alleged harassers of their role. And they listed some of these rules need to address the confidentiality of the investigation, the responsibility to interview both the complainant and the alleged harasser, presented an alleged harasser with a written document containing details of the complaint against him or her, separately interviewing all witnesses, taking appropriate notes and written statements, collecting and reviewing all documents concerned, and preparing a written report for the tribunal. Jamaica Aid Support for Life proposed that subclause 4 of clause 10, which now reads, a person who without reasonable excuse fails to comply with a direction under subsection 3 commits an offense and shall on summary conviction in a parish court be liable to a fine not exceeding $1 million. They suggested that the $1 million fine be significantly increased for an employer that is found in breach. JCTU proposed that subclause 3, that is an authorized officer on finding that a person is not in compliance with section 3 or 4, and sections 3 or 4 have to do with the issuing of the policy statement and to keep the environment free from sexual harassment. So they're suggesting that subclause 3, that an expansion is made to make the period of compliance for the direction of an authorized officer to be not more than 30 days. What is there is not being less than 30 days. So they asked as well for an upper limit to be included in that subclause. PSOJ noted that the Act does not highlight criteria or selection process or performance monitoring or communication, and they recommended that the officers, I think we had said this already yesterday, but I'll say it again. The officers, authorized officers, are trained and certified in sexual harassment, gender awareness and sensitivity, diversity and inclusion, and intersectionality. And that takes care of that, Minister. Those were the suggestions made in relation to clause 10.
All right, any comments on these recommendations?
Minister.
Yes, Senator.
The matter of mediation. I noticed that I think it was Jamaica, Independent Jamaican Council for Human Rights. They also recommended that, they also recommended that mediation be considered as a desirable option for certain sexual harassment matters. And I wondered if that is something we would consider.
Mrs. Robinson? You wish to comment on this?
Good afternoon, and thank you so much, Minister and members. So at this point, I will refer to the policy, which speaks specifically to a sample anti-harassment policy, and the sample anti-harassment policy deals explicitly with matters relating to the designation of authorized officers. And in it, it states that there is supposed to be a reporting procedure. The reporting procedure allows for persons to get their complaints documented in writing, and that report is to be made to a designated responsible officer. Once the report is made, it is the responsibility of the organization to ensure that the matter is sent further. In this case, based on what the bill is saying, it would be to the tribunal. It allows for a committee to be formed, and that committee would be a part of the discussion around what happens. It also states that, and looking on page 40, for those who actually were able to print the document, for the responsible officer / committee, it says that once the organization's name is inserted here, it says, let us say Bureau of Gender Affairs, for case in point, has designated the following persons, person or person, if we want person or a number of persons, as an officer or officers responsible for accepting and hearing reports of sexual harassment. Such an officer shall be trained to identify, provide counsel, and mediate instances or incidences of sexual harassment. So it is actually referred to here in the sample anti-sexual harassment policy. Continuing, if the officer determines that there is merit to the claim, the officer may proceed to attempt to mediate between the parties involved. If a mutually agreed upon resolution is achieved, it shall be documented and attached to the relevant records of the organization. If the mutually agreed upon resolution is not achieved, or if the responsible officer deems it necessary, the report shall be referred to a mixed gender committee of persons nominated, elected, and trained to evaluate sexual harassment claims. Finally, the committee shall take all responsible steps necessary to evaluate the claim of sexual harassment and make a determination of liability or lack thereof of the accused harasser or harassers. So there is scope for mediation as referenced in the anti-sexual harassment policy, Appendix 1.
Sorry, through you, Madam Chairperson.
Go ahead.
I heard everything she said, but I'm a new person to the Parliament, so I don't understand what you're reading from or how it relates to this. So can you just explain it to me a little bit, please, so that I understand? Because I'm not seeing it here in the bill, so I don't know where you're reading from or the connection, please.
She's reading from the policy.
Okay.
But could you just expand on that, Mrs. Robinson? Please.
Thank you, Minister. So yesterday when we were discussing, there was a reference to the policy itself, because the policy is, for those persons who are not totally aware, we had a sexual harassment policy. It was called an anti-sexual harassment policy because there was an issue with not having anything in place to deal with the matters of sexual harassment. And so there was a national anti-sexual harassment policy developed that would lead to legislation.
Right.
Oh, sorry, Minister.
And this was developed when? You want to just give her a little background?
It was developed, so sorry. Initially, we started this from 2008. And in 2011, it was taken to cabinet. And there was a discussion around how it is we should proceed, the naming of it, and the carry forward in terms of how we would proceed to move from policy to legislation. And based on that, we were encouraged to do sensitization. We were encouraged to do consultation in keeping with the government of Jamaica's consultative code, and to ensure that whatever is in the policy that would match what is required in terms of what persons thought were required, then we would use that to craft the legislation. So that's the basis on which I refer to this particular part, the sample anti-sexual harassment policy, which is a guideline coming out of the policy document itself.
Right, so just
I should indicate, Senator, that that policy document is now available to all the members.
Okay.
All right, Ms. Mack, was circulated?
Yes, Minister, I emailed it to everyone this morning.
Okay, thank you.
So question though, Minister, and I'm sorry, but I just need some guidance here. So when the bill is, it's not in the bill. So let us say this matter is brought, a case comes up. Is it that someone would go outside the bill and look at the policy, given that it's not in the bill? I'm not understanding that.
Well, you want to know how does it work?
Right, because I didn't think after the bill was written, someone would still go back and look at the policy versus the bill itself.
All right, so what I'll do, I'll ask Ms. Grant to just go through that with you.
Well, what happened, Senator, is because the policy was used, as Mrs. Robinson said, to inform the legislation, when the suggestion that was made about mediation, so you go back to the policy intent to see if it was already catered for in the policy, but it's not in the legislation. So what Mrs. Robinson read was to say that it was already contemplated in the policy, which is what we use to inform the legislation, that mediation should be attempted as a first step before it's escalated to the tribunal. So because it's there, I guess the point you were trying to make is that it could now be included in the legislation because it was originally captured in the policy intent, which
okay,
was
so that is
developed.
That's what I wasn't sure if we're saying it will go in the bill or not. And so we're saying that it will go in the bill. It can, because the policy did speak to it, so it's okay for us to put it here.
Okay, so at this point then, I don't know if Senator Gailey wanted to make a comment.
My comment would be around, again, this designation of the officer. Now, I've seen in other legislations where it is defined how these officers are appointed, which in this case, the minister with responsibility for gender affairs may designate persons. It is always good in my mind when you have this type of designation of an authorized officer for us to expand the role and function in the legislation of the authorized officer, what that authorized officer is entitled to do, so that there's no question around that piece of designation.
Okay, so Mr. Seeley Brown, Solicitor General, would you want to comment here?
Yeah, Chair, Senator Gale is correct. So it would be, it's now a matter of policy as to what functions, if we're going to include functions, we would want to give to these officers. And so it depends. It depends. It's yeah, on what the ministry wants. It's done like this. It's done like this in some cases, and they're designated, and in their instrument of designation, their functions are outlined. I understand for transparency for this particular type of legislation, because of the nature of what they may be required to do, it may be better to have it spelled out in the legislation.
So
And if you recall, Mrs. Seeley Brown, there was one submission that made reference to them keeping records.
That would have been that would have been yesterday.
Yesterday, right? Yesterday we made reference to
Yes.
one of the submissions that I would have demanded that they keep records for the purposes of the tribunal, or maybe outside if the matter goes outside of the tribunal.
Yes, sir.
all right. So, Solicitor General, would you want to make a comment here?
Nothing further, Chair.
All right. So, what should we ask at this point is that be taken into consideration in relation to the legislation and be included in the report. So our technical team would determine how that would be captured in the legislation.
So just to be clear, Chair, the two things that we have decided on so far is to include mediation as a step before it gets to the tribunal, and to specifically outline the functions of the authorized officer in the legislation, as opposed to just a certificate of designation.
That is what is being proposed, and I don't see any difficulty with that. So I think, members, that is what we would want to see, what we would want to have done. Senator Gale?
Yes,
I yield to Mrs. Seeley Brown.
Okay. Yes, Mrs. Seeley.
I just wanted to ask a question, Chair, with respect to mediation. Remember when we had our discussions yesterday in relation to how a complaint gets to the tribunal without necessarily having to use the internal mechanisms, where a person feels that those internal mechanisms did not cater to their needs. Is it that we say now that mediation becomes a necessary step prior to a person going, so you must have that mediation process before that person goes directly to the tribunal? We have to be careful. How are we crafting it in that context?
I was not here yesterday, so I missed that conversation because I had another committee meeting at the same time. I wasn't suggesting at all that it is a compulsory step. What I am more saying is on a case-by-case basis, if it is possible for it to be done on a case-by-case basis, whether or not mediation can work. I'm not necessarily saying it should be done first for every single allegation.
All right, so Ms. Grant, I think you could summarize what we are saying here. I think what you had said earlier may have given the impression that you do mediation before you go to the next step, which is not.
Well, I was just trying to find out, but given what Mrs. Seeley Brown said and putting it in context, especially as to the discussions of yesterday, that if it is, however we're crafting it, it cannot be crafted as a mandatory step. It would have to be, as Senator Cameron, as an option if you want to utilize it.
Yes.
I see the Soljan wants to say something.
Yeah, please go ahead.
Actually, Ms. Grant's last comment has clarified something in my mind, because we would need to be very clear when the option can be exercised, and you don't want it to be seen as if it's being unfairly exercised. So if the option is on the part of the complainant, I would need to I just want to make sure that however it's done, it's not done in a way that favors one side over another side, and that the option can be exercised fairly.
Yes,
so Chair, when we had this discussion yesterday, we spoke about the possible triggers to escalate the matter to a tribunal, and using the tenets of another legislation that mediation occurs, there may be a situation where both parties cannot agree on the remedy. And so there is always that option of utilizing mediation before you get to a tribunal that is compelled to make an award. And we have to look and examine whether or not the role and function of this tribunal gives the right for that award to be final and binding. So I see no difficulty in having it somewhere that presents the opportunity or the option for mediation to occur in these circumstances. Why I say that, the practicality of it is that, remember, in a workplace, you want to have continuous harmony. And such a situation may ignite the relationship between co-workers or between an employer and an employee or peer-to-peer, where the relationship becomes intolerable. And that may lead to other disputes. So the option of having a mediator mechanism may somewhat help the harmonious relationship to be maintained. So I am for that option to be included somewhere based on those factors.
Thank you, Senator Gate. I remember earlier MP Sibley's wanted to make an intervention. MP, do you still want to make that intervention at this point?
Chair, other members and the technocrat has somewhat spoken about it, but what I would want to do, I would want to wait until the section is crafted to really have a look at it, the whole process of mediation, because in listening to what was in the policy and the way the policy had seen it and it was crafted, I wasn't too inclined to accept it that particular way, because I see that it would have been fraught with some danger to, especially the part that says if mediation would come if the person who is adjudicating, which I have some difficulty with that in itself, felt that the person had a case, then mediation. I had some difficulty right there. But be that as it may, that is the policy. And based on what the technocrats are saying, I am more comforted that when that section is crafted, it may not, more than likely will not fall in those same terms. Thank you, Chair.
Thank you, MP. So the guidance have been given there to the technical team, and you would come back to us with something that we would look at. All right, so at this point, Ms. Grant?
Yes, Chair.
Right, so can we move on now, or we have sufficiently aired and have come to a decision in this regard and we can move on?
Well, no, not really. We haven't addressed some of the things. The increase of the $1 million fine for the employer in breach. Because all the fines are the same, at the same scale. And one of the suggestions made was that certainly where the employer is in breach, that the fine should be significantly higher than what is currently in the in the bill.
What is the feeling here from members?
My question with that, Chair, is, in other legislations, the application of that cost, aren't they usually the same? In this case, you're saying that all right, the employer is in breach of doing what? Not following the procedure, not ensuring that it takes place, not ensuring that the investigation takes place or the appropriate action.
Well, according to the clause, Senator, the employer would be in breach for not issuing the policy statement that is in clause 4, and in clause 3 for not ensuring that the environment is free from sexual harassment. So once the authorized officer conducts an investigation and realizes that there are breaches where those two things are concerned, it is for those two things that the employer would be held liable. And the feeling is that the employer should be made to suffer stiffer penalty than the 1 million scale.
You know, my own personal thinking in this is that the most egregious breach of an employer in this scenario is for not investigating the matter or taking the appropriate action.
But the employer should have a policy in place.
Yeah, you can have a policy in place, you know, a policy is a policy. The fact of the matter is that the most important compelling action by any employer in this scenario is to take the necessary steps or appropriate action where a complaint has been received. And the failure to do so, in my mind, would be the most egregious act. So my thinking would be to separate, if possible, if you want to speak of the $1 million being more, to separate that. Because in my mind, it is the action of the employer or failure so to do should attract a greater penalty.
Rather than any breach, rather than any.
But that's a breach. That constitutes a breach. What it does is that it really signifies a greater burden or responsibility. That's my thinking. Yeah?
Minister, if I may.
Comment, Chair?
Sure, go ahead. Who is this?
Okay.
I'm sorry?
Yes, Chair.
Who is this? Yes.
Are you hearing me clearly?
I'm hearing you clearly.
Yes. My thought on it is this. The tribunal should have the discretion based on the evidence that the tribunal would have heard, and should have a range in which the tribunal could make the award. And if the tribunal is of the view that it is aggravated based on the fact that the employer or persons in authority ought to have known or was informed and did nothing, then that would prompt, or that would be grounds for the tribunal to probably go to the ceiling of the fine. That's my thought on it.
Okay.
Chair, if I could just interject here, because I'm picking up two different strains of conversation. What I understand Senator Gale to be speaking about is the failure of the employer to take action upon being notified that sexual harassment has occurred. That's what I understand him to be saying. But what we're speaking about specifically in this clause is that it's the penalty for the employer, so it's still a failing, Senator. The penalty for the employer who fails to, one, keep the environment free of sexual harassment as per clause 3, and who fails to, as per clause 4, issue the policy statement. And we have it at 1 million, as are all the fines in the bill right now. And I just want to remind you, Chair, that in the earlier iterations of the bill, the fines were at varying levels. And when we got to the stage, before the bill was laid in Parliament, it was agreed that because of the not only the sensitivity but the seriousness of sexual harassment, that the fines needed to be upped. And so we put all the fines at the same scale, indicative of the fact that each failing should be treated seriously. However, Chair, if my view on it is that the fine does not need to be changed, it can remain at 1 million. But if it is the consensus of the committee members that maybe the fine needs to be upped a bit, it could stay for now, and it could be done when the time comes for the act to be reviewed, or we could do that now. But I as it is now, I don't think it necessitates a change.
So I just want to be clear, Chair, through you. I was merely just referring to the call or the ask for a particular group that had made submission, where they are saying that the fine for the employer in 4 should be up, and making a distinction that out of all of the breaches, the varying breaches that may be conducted by an employer, the one in my mind to be most significant is not treating with it, making the appropriate steps. So in other words, a report has been made to you and you did absolutely nothing about it. That is more egregious in my mind. If we were to support and expand and upgrade in terms of the cost for the breach. But I agree with you also. So that later on, we can examine when the legislation is reviewed, whether the value of that 1 million would require an upgrade. So I just thought I'd made that distinction, Ms. Grant.
So at this point then, we will note that we will review.
Minister, just for clarification on this, and I don't know if we have considered this, if I may.
Yes.
Yeah. The fine being at $1 million, is there a consideration? And yes, we're considering maybe an increase, etc. Is there a consideration for a small business that probably does not make that net profit in 5 years, in terms of, not to say, and by all means, not disregarding and not trivializing any form of sexual harassment, but in terms of the severity of the offense, and also the nature of the business and the capacity of and the capability of the owners to, one, execute the reporting process that might be necessary, and 2, to pay said fine. It is a different thing for argument's sake, for a company that nets $25 million to pay a fine versus one that nets 500,000. You know, I'm wondering if the weight of the fine should be a fixed amount versus a fixed percentage. Not in any way demeaning the offense, but also giving gravity to the significance of the offense in a particular institution that should be acting with such responsibility.
Thank you, Senator Longmore.
Chair.
I seek some guidance here.
Mrs. Celia Brown has her hand up a long time now, Chair.
Okay, please go ahead. Thank you. You said, Ms.
Thank you, Chair. In response to Senator Longmore's comment, the subclause speaks to not exceeding 1 million. So I think her concerns once they are, once they're aired to any judge, they will take that into consideration when they're actually imposing the fine. But I want to go back to what Senator Gale was asking, and I'm seeking some clarification from him through you, Chair. Are you saying, Senator Gale, that you think that clause 3, what is provided for in clause 3 should be separate, should be a separate offense and attract a higher penalty than what is in clause 4 because of the nature of what is required of the employee in clause 3? Is that what you're saying?
So I was saying it against the background that one group had made a submission that for the employer to be liable to a fine exceeding the 1 million. And when you look at all the breaches, in my mind, there is one particular breach that would stand out more egregious than the others. And it is against that background that I would support that one being pulled away and to be separate, because that one is saying that the employer would have failed to act once a report has been given. You can be guided for making policy statement or developing policies, you know. You can be guided for setting out an established procedure, but failure to act is where that employer would have failed to either prevent or protect the employee. And I'm of the profound view that that is the area that requires more attention.
So in that case, Senator Gale, maybe then we can link that particular offense, if the committee so agrees to create that offense, to clause 5.
To clause 5.
And not necessarily clause 3. Look at clause 5.
So it would be subject to 5(1).
No, you just create the offense, right? The failure to take action to deal
right
with
there.
Harassment. Is that what you're thinking? Because that would be my thinking if you're going to ask for an increased amount. Okay. Okay. So, Madam Chair,
because what you want to create, Mrs. Celie Brown, is the protection that allows for a deterrent on the part of the employee not to act.
Yes.
You really want the employer to act. You really want the employer to respond in these circumstances. You don't want a situation where a worker brings the matter forward as an alleged victim and there is no response whatsoever. And we have seen situations where an employer would avoid it and hope that it goes away like a bad dream.
So in that case, Madam Chair, it could be that the committee may wish to consider, because clause 5, subclause 2 of that clause just says that if the employer fails to take immediate and appropriate action, he shall be liable for failure to act. But it doesn't say anything else. So maybe that is where, if we want to create an offense, we may need to look at that provision and allow the clause that we're discussing now to stay as is. You could increase the penalty there. That's my thinking, Chair.
All right, and I would agree, and I would ask members if they agree with your thinking, and we will be so guided.
MP Tamika Davis is about to agree.
Yes, go ahead, Ms. Davis.
You know me too well. Good afternoon, colleagues.
Okay, MP Davis, yes.
Came in on the back end of the comments being made by Senator Longmore. And I see that it has ably been addressed, that the fines really say not exceeding 1 million. So it is always open to the parish court judge to make a determination, having heard the evidence in this particular case. So it would not be that it is a one figure that applies to everyone. It really would be determined by the merits of each case. But that was already addressed. And yes, I was agreeing with Senator Gale as well. I do see where in 5.2, clause 5, section 2, that it leaves much wanting just the word shall be liable for failure to act without saying what you when you fail. It is a lacuna that can be addressed.
All right, thank you, MP. So,
Chair, sorry, I have to bring this back up. I'm still not feeling that we're taking all matters into consideration. I don't know if I'm not getting it, but a fine not exceeding $1 million. If for argument's sake, courts Jamaica has this issue and one of their HR persons is not responding, not exceeding 1 million is, I mean, $1 million is for them is nothing. And for me, it probably would be more the publicity, the negative publicity that might be associated with it. So I'm not sure if I am not grasping it properly, but in my mind, there should be some reflection as to the value of the impact that the monetary value would reflect on them. $1 million for a small business owner is very different than than what it would be for someone who is listed on the stock exchange and not the junior stock exchange, you know? So I'm not sure if I'm not grasping it, but I think that, and yes, I understand in terms of the parish court judge having that leniency, but I think that we should legislate to ensure that the message is adequately conveyed, as Senator Gale is suggesting. But I'm still not fully sure if in my mind that we're grasping the full impact that it could have for someone who is quite capable of paying that fine and it not really making a difference to them.
So Senator Longmore, what would you suggest?
Well, it like I said, possibly a percentage of their last year's profit, maybe something that reflects that it is. So if it's a small business owner, he knows that his fine will be probably 0.5% of his thing, or 10% as the case may be, especially if he's a repeat offender, or if there's a history of this report being made and them not acting. So, you know, that is where I would want to go with it, because again, at the other end of the scale is that the offense could be really, it's not a criminal, it doesn't go into a sexual offense, but it's a serious sexual harassment issue. And a small business owner could lose their life saving based on that one fee. I don't know if we mean to do that also. It is not a criminal offense, mind you. It hasn't gone to the extent where it is now a criminal offense, because then another piece of legislation would kick in. But are we also going to now have that situation where we could bankrupt a small business owner? I don't know. So I'm just putting it out on the table.
On one hand, I think we could bankrupt the small business owner, and we could also allow the large business enterprise
exactly
to get away with
exactly. Yeah.
Senator Gale, as someone who had to work between employer and employee, what is your take on what Senator Longmore has put on the table?
What Senator Longmore is suggesting is that you see, you're asking me to bat for the employers here. My concern is really
who have to work between both, representing the employee. What is your
and that's why, Chair, I made the distinction in terms of the possible scenarios, because all breaches in this case has indicated a fine of up to a maximum of the $1 million. Right? I'm saying that the most egregious breach is the one like where an employer does nothing. We must compel the employer to act.
Yes, yes. Peg it to where he will feel it.
But you see, you can, in that case, when you peg it to where he will feel it, you can make a distinction between an employer being small or large. What you're suggesting, it's eggs or young ones.
Yes. I think we are going down a path that could be difficult to define. I'd love to hear what the technical team has to say.
A fine not exceeding, a fine not exceeding may, on the conscience of the parish court judge, make a determination if a proper submission is made that really I know I should have done it, but I can't afford it. Would that parish court judge take that into consideration to say, okay, 700, 500, whatever?
Ms. Grant? Thank you, Senator Gale. Thank you, Senator Longmore.
I was just saying, Chair, that I see the Solicitor General and Mrs. Seeley Brown.
Yes.
They have both raised hands.
SG, and then Mrs. Seeley Brown.
Sorry, Chair, actually, Mrs. Seeley Brown had put up her hand before me, so I will defer to her.
Okay, please go ahead, Mrs. Seeley Brown.
Thank you, Chair. Just to say that we have to be mindful that before the court issues any penalty or sanction, they would obviously look at the means of an individual or a business before a penalty is awarded. So I don't think that we need to be too worried about crippling a small business in that case, Chair, when you look at how the court would operate when it's actually fining an offender. That's all I'll say for now.
All right, thank you. Solicitor General, please go ahead.
Yeah.
Okay, I was actually going to see if I could try and provide some guidance. You could have a provision that has a different penalty regime for body corporates. So that is one option. And we do have that in some pieces of legislation where we realize that you can have an individual charged for the same offense that a body corporate can be charged with, and you have a different penalty scheme. The other thing I would like to bring to attention is something that Parliament recently amended in the Proceeds of Crime, an amendment to the Proceeds of Crime Act, where it dealt with penalties for offenses by bodies corporate. And I'll just read what the section said. In determining the amount of any fine to be imposed on a body corporate under this act, the court may have regard to A, the nature of the business carried on by the body corporate, B, that's not so relevant here, but B, the size of the business concerned, including the level of profit or total revenue generated therefrom by the body corporate, and C, any other factor that the court considers relevant. Now, I think this is something that you can take into account because it would address the issue raised by Senator Longmore, as well as Senator Gale.
Thank you so much, Solicitor.
Thank you very much. Thank you.
Thank you so much. So could we please take this into consideration? What would you recommend?
Sorry, just for the record, Minister, it's section 139 of the POCO, and it was a 2019 amendment. I'll tell you the Act number in a minute. It was Act 14 of 2019, and it's section 139.
Okay. So, SG, what would you recommend at this point?
So, I don't usually like to weigh into these discussions because they're really more policy, and normally we would say that the advice usually from the chambers is to ensure that you have consistency with similar or like offenses, but these, you don't really have anything like or similar with these. I do take the point, and I do think you could have a separate offense for bodies corporate. And I think that is definitely something that the committee would have to consider. And I think maybe you should think of having a different range of fine for a body corporate compared to those that would be applied just to an individual. You don't want a situation where it's better for somebody, it's cheaper for somebody to actually breach the law.
Yeah.
Meaning you could have a company that will say, well, because the fine is this, I won't do anything and I'll just pay the fine. You don't want
Exactly.
that situation. You
Exactly.
do want a penalty to act as a deterrent.
So, so members, through the guidance that we are now getting from the Solicitor General, would we want to ask that they take into consideration, if we agree that they take into consideration how this could be incorporated into the act and put in the report? Senator Gale or Senator Longmore?
Yes, yes, Chair. I would appreciate that. Thank you.
Chair, I'm for that. What it demonstrates is that we would have gone through, expressed the concerns and come up with a possible solution. I like the idea of establishing ranges depending on the type of the size. Well, let's not use size because you can have a small organization earning billions. But
Yes.
you know, there are ranges. And we still utilize whatever wording, a fine not exceeding X.
All right, so SG, we're asking you and the rest of the team to take this into consideration.
Okay, but what penalty, what fine is the committee thinking of in terms of our body corporate?
Well, you want us to go back to that? You want us to just look
Meaning
at
the number, if the 1 million would apply to an individual, what kind of penalty are you thinking
and
about?
one would be not less than, and the other one.
Well, yes, they all are usually not less than, because we provide maximum fines, generally.
Yes.
So we would have to have an idea of what kind of maximum you're looking at for a body corporate.
Senator Longmore? Senator Longmore, you have a comment here? In the meantime, Ms. Grant, you may want to make a comment, or Mrs. Robinson?
Well, just to say, Chair, that in light of the discussions that have taken place so far around this, and as the Solicitor General said, if the fine is to act as a deterrent and we're thinking about body corporates, then the fine, of course, it needs to be hefty enough to act as the deterrent that we're seeking for it to act as. So certainly it's not the 1 million, certainly it's not 2 million. So what are we? Are we considering 20 million, 50 million? What is the number that we're looking at?
And just to be clear, are we separating the breaches? Are we treating all breaches on the same level, or are we suggesting are we accepting what I had suggested, that the most egregious breach in this would be for an employer not to have acted? You mute, Minister.
Maybe for one, we want to separate the breaches, and we also want to introduce a different regime for body corporates.
Maybe we need some guidance now in terms of where you have the body corporate as opposed to other types of organizations. What would have been the range, so that we could say that would have been applicable in another legislation? I know poker might be a harsh one with those fines to use.
Tell us some of those numbers, some of those figures that are used as a deterrent. SG? 5 million? SG, can you guide us here?
It's really a decision for, I mean, okay, so penalties at the parish court, we don't usually go in an amount exceeding 5 million because we don't want to trespass into the jurisdiction of the High Court. So that is sort of the limit that we have in any law. That's the highest. Usually a little less. More often than not, you will see $3 million penalties for the parish court. And just to indicate, by the way, that there is a mechanism in this bill for monetary penalties to be amended. It's an easier mechanism, so it's the minister who may do it by order, subject to affirmative resolution. So just bear that in mind as well. That this is not fixed for life or until you have the review of the act. You can also have an easier mechanism with which to amend your penalties.
Well, SG, may I suggest, members, then, that we go for corporate 3 million? And certainly over time, if we feel that we need to be to increase it, by order, the minister can do so. Senator Gale?
And so what would be if corporate is a fine not exceeding 3 million, then what would be for those that are not corporate?
I would say the million.
The million?
Yes.
Well, let us ask Senator Longmore if she would be in agreement with that.
Senator Longmore?
Yes, Chair. I think that sounds more reasonable. Yes.
And
Thank
then
you.
the minister by order can always increase.
Yes, Minister, I like
Yes.
my order. Next thing when I face the employers, them says me cause it.
Just blame it on the minister.
But Chair, do you mind? Mrs. Masado has a point to make relating to this whole issue. Although I think there is a senator that has her hand up. So maybe
I think Mrs. Robinson also wanted to comment.
So the senator could go ahead with your permission, and then I would ask if Mrs. Masado from the chambers could also be given an opportunity.
Okay, but please go ahead.
Thank you so much. I just wanted to support what was being discussed. And when I raised my hand, it was to, sorry, Minister, I keep forgetting to start my video. Yes, I wanted to support the 3 million. I think it's a good option because when it is, for example, the poker bill, that legislation, it's the organization that has done something. So you have a really big fine. But this one, it is someone within the organization. And while the organization should be held accountable to some extent, I didn't think we should go to an extreme. So I wanted to support the 3 million. That was going to be my suggestion.
You're muted, Minister.
Mrs. Robinson, please go ahead.
Thank you, Minister. I'm really truly ecstatic about the fact that we have reached to this point where we're looking at raising the bar, because in the 2018 bill, it was 500,000. And that was considered almost like a slap on the wrist. And that's the reason it moved to 1 million in the 2019 and the 2020 iteration of the bill. I think that having it raised to 3 million for that group, the persons who can afford it, corporate bodies, would send a clear signal that there is a zero tolerance approach to sexual harassment, because this has been on the table, Minister, as you know, for so many, many years, decades. And so we think, since persons are asking for other types of harassment to be included, like street harassment, which we are not able to include at this point, I believe if the penalty is larger, then that will send a very clear signal that we are serious about this matter. Thank you.
Thank you, Mrs. Robb. So over the years, we have now reached the 3 million for corporate entities and 1 million for the smaller entities. I think we're moving in the right direction. But
Mrs. Masada, Minister.
Yes, please go ahead.
Thank you, Chair. I'm still on section 5 of the bill. I know that the discussion happened earlier and we were discussing whether or not a breach of section 5 should be considered a criminal offense. And in that case, it could go to the courts. But I was looking at section 5 again and realizing that in subsection 2, well, in section 25, it provides that a person who, where section 5 is breached, a person can make a complaint to the tribunal and then the tribunal will deal with it and can make certain awards. So I just wanted to raise that issue so that when everyone is contemplating whether or not section 5 should be made, and then persons can go to the court to get that remedy, but at the same time, are we saying that they can still go to the tribunal to get an award? There would be some kind of conflict. There would have to be one option or the other. So just for our consideration going forward, we need to be aware of that issue.
Okay, thank you. Thank you for raising that. Senator Gale, you want to make a comment, or anyone else want to make a comment on this?
I'm just trying to digest that comment a while ago, Madam Chair.
All right, Mrs. Masado, can you repeat and can you just lay it out clearly to us?
Sorry, if Chair, maybe Mrs. Seeley Brown can just offer some further guidance.
All right,
Because her hand is up.
Mrs. Seeley Brown?
Thank you, Chair. Well, it's just that rather than make it a failure, that it's something that the tribunal would look at. When we get to clause 25, we may just need to amend that if we decide that we want to make clause 5 a strictly criminal offense, Chair. We then will have to take it out of the one of the complaints that can be made by the tribunal under that clause. It's just an amendment. We will just have to basically remove 5.1 from clause 25, because you can't have it both ways. If we're going to decide that that's going to be, we're going to criminalize that action, and that person is going to have a remedy before the court, it can't be that you can go to the court and then go to the tribunal to redress.
Mm-hmm.
And that would have dealt with the concern yesterday that I raised about the either or, the tribunal or the courts.
Yes, yes.
And so we have to be specific in terms of the jurisdiction and what application one would use in terms of a particular jurisdiction. The first preference in my mind, would be for issues of this nature to go before a tribunal and just get the settlement there. But in the case now where you're mute.
Sorry. You remember in this case is the employer's action.
Is the breach.
Failure.
Is the action.
Right. So yes,
right.
so that is what we that should be a criminal.
It's not the issue, it's the breach.
Yes.
Right.
Yes, the breach. That's right. So we would want to look at that. All right, so we could make a note that we go back to look at that if we want to make that criminal offense where the employer is in breach. Miss Grant, you have any comments on this?
No, Minister, I agree.
Just from my thoughts, Mrs. Seeley Brown. So, you see, and I'm looking at 25. And so, at what point would the breach be presented? In other words, when are we going to recognize that the breach would have been made to trigger it to go to the court?
but I would, if you look at what one is saying, it's where he fails to take immediate and appropriate actions. A complaint made because he has been sexually harassed at the workplace, and that the internal mechanisms weren't triggered, nothing was done, and that person now would have a right to have that issue heard by the court.
Or by the courts. Okay.
Mhm.
I'm just trying to, for the lay person in this, you know, who would have been aggrieved and an employer would not have responded, how you trigger it to the courts? Who they go to make that complaint for it to get to the courts?
Well, it would have to be their action. They will have to take that action.
They would have to take that action by themselves.
Yes, yes.
And so that procedure, if it can be, you know, in terms of a requirement of the legislation, if it can be so captured.
But we would have to redraft the provision, you know, it wouldn't say, just like how we have a person who alleges that, when you look at 25, but the provision would have to definitely be redrafted to say that where the employer fails to take immediate and appropriate action, he commits an offense and shall be liable to a penalty of whatever or to imprisonment. So it would have to be redrafted to show that.
So when we get to that, we deal with it then.
Yeah, but just like, because the person is the one who will actually make the complaint also before the tribunal. So it will be, rather than just the tribunal, you would then be going to the court. So it's not a difference really in the procedure. It's just that you're now going directly to the court rather than taking the action before the tribunal.
Before the tribunal.
Yeah, Okay. Is it that you're saying, Senator Gale, that because I sense that you're not comfortable. So is it that
No, don't judge by my facial expression on camera.
Because I'm wondering if you're thinking it is easier.
What I'm doing is I'm trying to wrap the sequence of events around my head in terms of, so an employee raises a concern and say that they have been sexually harassed, and it should trigger a certain appropriate action from the employer.
Right. And I see, but I see the point you're making, and we're having a discussion here. I'm having a discussion.
Right. And so that employer would have failed to act.
Yes, but I wonder if it's a bigger point where you're thinking it may be easier for a person to seek redress before a tribunal rather than having to take an action before the court where he may have to hire an attorney. And so that's why I'm wondering if
listen, I know that I have siblings and I have Tamika Davis on my side, and I don't want them to believe that I'm taking the responsibility out of their hands. But maybe they can look at it also that they can act on behalf of the victim before the tribunal.
Yes. And I want to raise a point.
And so there's no pecuniary advantage being expressed here by the trade unionists in the room.
Yes.
And I guess one has to take into consideration as well, going through the courts, it may take much longer.
Yes, Chair.
It may take much longer.
Yes, Madam
and
Chair.
the cost
associated
with that.
Yes. So that's then we will, I guess that is that's a policy decision. Not as well, a decision that the committee is going to have to make as to whether you'll want to leave it with the tribunal, and if you want to increase the award that maybe the tribunal can offer to a complainant, if that is done, or you want to make it a criminal offense.
And remember, I had asked now in terms of the authority of the tribunal to make the judgment or awards compelling in nature.
Yes.
So that if the tribunal awards X, it has to be addressed.
Yes.
But that was just my thinking. Thanks for unraveling it for me.
But Madam Chair, I think when we get to clause 5, clause 25, may I suggest that we look at it, examine what awards can be issued by the tribunal in that regard, and then make a determination as to whether we will make it a criminal offense or we would leave it in the hands of the tribunal. So we flag clause 5, I'm suggesting, until we get to clause 25.
Okay. All right, thank you, Mrs. Celia Brown. All right, so Miss Grant.
Yes, Minister.
All right, we gave you a long break there. You want to? We gave you long enough to catch your breath.
That's fine. That's fine.
So over to you now.
Okay. All right, Minister. So we part that for a little. So we're at clause 11, which is the establishment and constitution of the tribunal. And these are the suggestions that were made. Ministry of Labor and Social Security recommended that persons qualified in labor relations form a part of the panel which hears complaints in relation to employees. The Rent Assessment Board proposed that psychologists be included as members of the panel. The IJCHR proposed that members experienced in human rights, human resource management, and sociology be appointed to the panel, should have the requisite training and experience, and advocated that it be specifically mentioned in the legislation. And the Jamaica Aid Support for Life asks that one of the final 4 members be a representative of civil society possessing the requisite skills. Ministry of Education, Youth and Information, we're now at Matrix 2, made a recommendation that a person who has experience and empathy in matters relating to children and youth affairs be considered as a member of the panel, and so considered under clause 11 subclause 1 paragraph C that states other members. So they're asking that a specialist person with experience and empathy in matters relating to children and youth affairs be considered there. The PSOJ made a recommendation that of the 12-member tribunal, that 5 members from each gender and a panel of 3 should include 1 of each gender. They also recommended that appointments to vacancies should meet the overall standards set out in clause 11. And they went on to say that the act does not highlight criteria, selection process, performance monitoring, or communication with public on performance. There is no maximum turnaround time for cases to be heard and decided on by the tribunal. And they further proposed that the bill should specify criteria for selection process. I think that's there, but anyhow, performance monitoring process, communication on performance with the public, turnaround time expected for decisions, and more than 4 mediators to be added to the panel. And those were the suggestions relating to clause 11.
Okay, so members, your comments are invited here.
Chair, if I may.
Yes.
I think it should be definitely recognized that a number of submissions made the recommendation regarding the inclusion of a mental health person on the tribunal. I think it probably was more the rule rather than the exception in terms of the persons in that sport. Whilst I recognize the definite need to have someone who is proficient with respect to child development, etc. I think let me ask this first. I'm not sure. Would the tribunal have the wherewithal to request, like, the presence or invite, for want of a better word, an expert, a consultant, if they're dealing with a unique case or a particular situation that may require expertise beyond what is present on that service?
Well,
Would the tribunal have that leeway?
the tribunal should have that flexibility. Mrs. Robinson?
Thank you, Madam Chair. Yes, I agree with you, Safaro, Senator Longmore. I remember your conversation specifically, and I just added it right here in my breakout on the Sexual Harassment Tribunal structure, that you were very, very firm that we needed to have a mental health specialist, and we also are thinking of a clinical psychologist on call. Now, in terms of best practice for this kind of issue, sexual harassment is one of those issues that allow for a number of specialists who are so trained in the area to provide type of support, psychosocial support, and so on. In terms of the breakout of the tribunal, it indicates in the bill that it should consist of preferably, or as recommended, 12 members that are appointed by the minister. The breakout is that the chairperson could be appointed from one of the attorneys. The members should have the composition being at least 4 persons who are attorneys at law. So they are very versed in the area of the legal field, the legal fraternity. 4 mediators, 4 other qualified members. And for these 4 other qualified members, recommendations are that they could have training in labor relations, certainly persons with gender knowledge, persons with training and specialization in trade union, background to trade union, justice of the peace, restorative justice, and so on. So yes, there is scope for expanding and to make sure that in terms of how you select the members of the tribunal, that they are carefully selected, that these persons are able to provide the type of guidance so that whatever is agreed on in terms of the final decision, that the persons would feel as if the jurisdiction, whatever it is, the claimant would feel as if justice has been served. It also states that there is provision for a secretary to keep a record of the proceedings of the tribunal. That should be kept in safe custody, along with other documents of the tribunal. The recording of the statements from the witnesses and so on also should be confidential. And that person also performs other duties as required. In terms of jurisdiction, the tribunal has the jurisdiction to hear and determine a complaint or a claim made either by a worker, a resident, a student, a ward, an inmate, a patient, or a member, as the case might be, of an institution that their employer or the person in charge has failed to act in accordance with the Sexual Harassment Act. They should hear and determine a complaint made by a person in relation to any matter arising under the relevant sections and make the awards that are specific to the act itself and in terms of their knowledge and expertise and the gravity of the offense and how it is that they have heard the cases, how the report is prepared, so that at the end of the day, the accused would feel as if justice has been served.
Okay. So my question, Mrs. Robinson, thank you for that clarification. What I was trying to find out, whilst we have, okay, so the set tribunal, the set constituents would have that composite structure. What would be the avenue, if necessary, say an opinion or insight into a particular area is not covered by anyone there? I know we're trying to broad base. Is it possible to get that opinion in? Because the reason why I'm asking this is that the suggestion around a person who is versed in child development issues and child health, mental health, a psychologist, a clinical psychologist, and I would not just say a clinical psychologist, I would actually leave it to be a clinical psychologist or psychiatrist. Those persons would be trained in child development and would have that as a prerequisite to get that level of training. So I don't know if it is really necessary, because we're trying to ensure that we have all input at that tribunal level, and those positions are quite precious. I don't know if we need to have a specific child specialist, because that purview would have been covered by a clinical psychologist or psychiatrist. But if we are to get that level of input, I don't know if we would have that you know, beyond what the psychologist, psychiatrist could provide, if we would have that avenue available. That's why I'm asking that question. Thank you.
Mrs. Robb?
Thank you, Madam Chair. Oh, yes, absolutely, Senator Longmore. In terms of the broad scope of the tribunal, the idea is to have everything at the disposal of the persons who bring their cases. So that cadre of specialists that we would have, that's your recommending, psychiatrists or clinical psychologists, medical health specialists, persons who are trained and can offer the psychosocial support and counseling, absolutely yes to that. That would allow for persons to be able to get the kind of support they require and to feel as if they have been given the right to speak up and to have their cases heard, and that they would feel like they have had redress that is appropriate based on the gravity of the offense.
Okay, so in that case, personally, I think that the requirements to serve and to understand and to see to the youth and the child issues would be covered by a clinical psychologist or a psychiatrist. That's my contribution there. Thanks.
Thank you, Senator. Senator Gale, you wish to make a comment or?
Yes, I wish to make a comment, but Senator Natalie Campbell Rodriguez was in line before me, and I will yield to her because I want to hear what she has to say.
Yes, I'm not seeing the hands. I don't know why, but I thank you all for assisting me in identifying the speakers. Go ahead, Senator.
Thank you so much, Madam Chairperson. And thank you, colleague Senator Gale, for yielding and for being a gentleman as usual. I just wanted to make some comments on section 11 that we're in. I do support what Senator Longmore has said in terms of if we have a clinical psychologist / psychiatrist, whichever one it is that we go with, on the tribunal, and there is room to bring in someone else as needed to handle child cases, then I support that. If there weren't that facility, then I would say we'd need a child-specific person because there are different disciplines. Even though all psychologists, psychiatrists have to do some training in terms of children and their psychiatry, they look at it in terms of the psychological aspects, not the welfare aspects, which are oftentimes quite different. That is why we now even have degrees in youth development and in child development, because there are specific fields. But I would like to suggest that in addition to the mental health personnel, someone who is from the Employers Federation. I do believe someone from that entity should be included on the tribunal. Or we could become one-sided with how the tribunal is viewed. And of course, someone from with expertise in labor relations. I think those two are important for us to also have. I also want to revisit that sensitive issue that I had brought up weeks ago, that I do not believe that we should have an equal amount of male and female on the tribunal. But instead, because women are disproportionately affected, we should have more women on the tribunal than we do have men to balance that whole issue of the fact that we're disproportionately affected. So those are the points I wanted to make.
All right, thank you, Senator. And I will now move to the youngest senator on the team, Senator Gabriela Morris, to get her input as well. Senator Morris, go ahead.
Yes. Well, Senator Rodriguez just kind of cleared up what I wanted some clarity on, which was really, questioning if we would include the childcare personnel in the prescribed group for the tribunal, or it would be a case where they would be called in on special instances to provide, support in that regard. I just wanted some clarity on how the setup would be outlined.
Okay, thank you.
Don't go yet, Ms. Grant, because what I'm about to say, you may want to assist me with your response. So we're looking at a 12-member panel. And it says in A, 4 members who shall be attorneys at law, who have each practiced for at least 10 years. So there are some experienced lawyers. Then it says 4 members who shall be trained, shall, not yet trained, shall be trained and certified mediators who have each practiced for at least 2 years. I would want someone to explain what the shall in this case, with that appears to be an intention to train, but would have practiced. Practicing what? For at least 2 years. Then no, C speaks to the other members. And the other members now, I assume, is where the skill comes in. Whether the labor relations, whether the clinical psychologist, whether the gender affairs persons. Now, we run a little risk here with these 4 members if we're not careful, because this tribunal chair may have to be sitting not on a whole as 12 members hearing a case, but in divisions.
Yes.
Because you may have a number of cases being presented before the tribunal.
That's right.
And my concern is that how would you get the unique skill to be on a particular division to support that complement that is required? Okay, having done that now, then in tidying up the role and functions of the tribunal, tribunals normally make their own rules. And Mrs. Robb made reference to a number of applications around the setting up of the tribunal that is not contained in this prescription. Where are we going to capture those? Which may very well include the appointment of members, the reappointment of members. If a member dies, unfortunately, whilst a matter is being heard, how that is treated. If a member decides to the resignation and the appointment of another member, how those things go. So these are things that we really have to flesh out in terms of the establishment of this powerful, awesome tribunal. So, Ms. Grant?
Senator Gale?
Yes, yes.
A lot of food for thought. And I see where Ms. Grant, before I ask you to take this on, I'm going to acknowledge MP Sibley's. Go ahead, MP.
Yes, Chair. Let me quickly go through what I've been hearing and see if I can get some clarification, and Ms. Grant may be able to assist. And I noticed that Senator Gill had beckoned my learned friend, Ms. Tamika Davis, but she is yielding at the moment. But with regard, first thing, is there a 4-member to a tribunal? Because the word tribunal, to my mind, means 3. Three persons that sit. The other thing that I am so sure if we want to, because I know from most tribunals, my experience that most tribunals, with regards to any matter that may arise, like expert and so on, the expert, it is usually the case that experts are called in. The tribunal have the authority on its own volition, or it can be prompted by either parties that are before the tribunal to have an expert in a particular area to be there. Senator Rodriguez and I have had this discussion outside when she mentioned it initially. And I have nothing to assure me that because of more person than the other gender that is on a panel will cause a decision to be flawed. And I'm not, and that is where my mind is. If we should be is it that we are conceiving that because this issue affect mostly female, and I'm just saying that based on what I've been said. I have no record right now, no statistical record, but I will accept that. Does this mean that decisions that come before our courts that affect female sexual assault, even in the criminal courts, have we found that the male judges would come to a decision that is not reasonable or not just? And so I would not go, and that is why my mind wouldn't go as to specify that it should be more female on a panel. I am all embracing that panels should have both gender. Now, it could be more female at one time. It could be more male at another time. But I am for it, there must be a mix of gender on a tribunal where it is possible. And if it is not possible at all based on the availability and so on, that all female can be on a tribunal. I have seen all female court sit, a full court, all female. I have seen all males sit. And so I don't know if we should make any such legislation, the legislation to be such that it may affect us in the future where the tribunal is not able to sit because it would be sit in the breach of the act. And that is really those are my comments. I think we should be able to have a bill that will be able to get the spirit of what we are trying to achieve, where there are experts, whether or not, if we don't experience among the tribunal, that the tribunal should be allowed to obtain any experts that it so need in order to understand. And in fact, it is even better, even where members of the tribunal are particular area, it is also better to make it comes to an evidential base by bringing in an expert to give that sort of analysis and that sort of thing that it is said under oath and not something that is based on Dwight Sibley's, who has the qualification, who sits on the tribunal that says, okay, based on my expertise in the particular area, you know? But Dwight Sibley can say that based on the evidence given by so-and-so who is qualified and all parties agree that these persons are qualified, because when you bring on experts, it is usually agreed by the court. I rest.
Thank you, MP Sibley's. You have said a lot there. A lot of food for thought. Ms. Grant?
Yes,
Or before I invite you, any other member would wish to comment? All right.
I would, Chair, I would after. Thank you.
Go ahead, Senator.
I thought you said Ms. Grant.
No, Senator, if you wish to comment, go ahead before I have.
Okay. Okay, so just two quick things regarding, may I suggest the requirement where you had of some of the attorneys having a minimum number of years experience. I would suggest the same with respect to the mental health professional, especially as it would obtain to the possibility regarding the children's issues. And yes, it is, I do recognize Senator Campbell Rodriguez's point, but I would definitely see my objective would be to ensure that we, with the numbers that we're afforded on the tribunal, that we have as much full coverage of experience relevant to the issues as is possible. The second point in terms of the gender balance of the tribunal, personally, I would prefer that it is the qualification and the capability of the individuals that we definitely put at the forefront, but I would love to see a female chair in it. And I think that way, because of the nature of what it represents, if it's even in this moment until we maybe make an amendment, but I think that it is really that impactful to recognize that it does affect the female gender in that capacity. But my primary purpose, I think, in terms of the constituents is the experience of the individuals and their ability to refer to the issues that we may face. Thank you.
Thank you, Senator. Okay, Ms. Grant?
Yes, Minister. Quite a lot to unpack in the discussion that has gone on so far. All right, I will start first with what Senator Gale asked. The clause 11, subclause 1, paragraph B, that currently reads 4 members who shall be trained and certified mediators who have each practiced for at least 2 years. What the shall there means, Senator Gale, it's a mandatory shall. So, and in the legalese, what it really means is that you must be trained and certified and having practiced for at least 2 years. So you have to have these qualifications for you to even be considered. That's all the shall there means. So it's mandatory. It has to exist before you are even considered. So that is what the shall.
So this is assuming, therefore, that for us to select those persons, we form the assumption that they would have already been trained and certified and practicing.
Well, it's not an assumption. You would have to see evidence of the training and certification. So it's a qualification requirement. Just like with the attorneys at law, you would need to be assured that they have each practiced for at least 10 years. It's the same with the mediators.
Yes.
It's a qualification requirement for you to be a sitting member of the tribunal.
Oh, so that is across the board.
When you say that is across the board.
In terms of the minimum years of practice.
Well, for the tribunal.
In their, yeah. Okay.
Qualification.
I don't want to attempt to be playing with words. I can understand clearly shall be an attorney as opposed to shall be trained.
You're saying shall be trained as an attorney?
No.
Oh, what do you mean?
A says shall be an attorney. So that's a clear qualification in my mind.
Yes.
B said who shall be trained and certified. And
so would you prefer it to read who shall
and
be
each
trained
should be
certified?
practiced. So there are two qualifications here, you know, in this one.
Yes. Yes.
You have to be trained and certified.
Mhm.
And then you have to be practicing.
Practice,
So you can be trained and certified, but you don't practice yet for 2 years. So you can't qualify. If in June of this year,
yes, that's what it's
we
saying.
establish this tribunal.
Yes.
That's what it says. So do
All
you
right.
have difficulty with that, Senator? What's the difficulty you have?
Let what Miss Grant says cement in my head. I'm just having a problem with the shall be trained, as opposed to somebody who has already been trained.
No, but somebody who has already been trained, it's not the recency in the training, you know. It's once you have been trained and certified, the shall is just a requirement that you have to be trained and certified.
Yes.
It is a requirement, a condition precedent that will qualify you for consideration.
All right.
So whether you were trained April as opposed to trained 20 years before, once you were trained and you were so certified and you have practice, because as you can well appreciate, the theory is different from practice. So once you were trained, certified, and you have practice, then you could be considered. So that is what it's saying. I see Mrs. Seeley Brown, I want to say something about that, but let me just address the other two things before you chime in there, Mrs. Seeley Brown.
Let Ms. Seeley Brown clarify this particular point.
I was just going to say, Chair, to Senator again for you, that shall is just mandatory legislative language. So it doesn't mean that you are to be trained, but prior to taking up the position, you must be trained and be certified and have practiced for at least 2 years.
So it brings the three together.
Yes, yes, yes.
Right, so you're fine now, Senator?
Yeah, no, I'm fine, I'm fine.
All right, very good. Ms. Grant, thank you, Mrs. Brown. Ms. Grant?
Yes, Minister. Okay, I wanted to go back to the youth person, or the whichever person Senator Longmore said, who it would be, a child psychologist or so on. One of the things that Ministry of Education suggested, specifically what they asked for, is that paragraph C of clause 11, where you have the other members who shall be selected. So in the other, that this paragraph is expanded to include, after consultation with the minister responsible for youth and children. So here we have minister responsible, who appear to the minister responsible for gender affairs, after consultation with the minister responsible for justice and the minister responsible for labor and social securities, to be qualified as having had the experience of and shown capacity in matters relating to labor relations and gender affairs. So they're asking that it's expanded to include as well, under the consultation, after consultation with the minister responsible for youth and children. And if we are accepting that insertion, then, and agreeing that it should be made, then we'd also have to add, and shown capacity in matters relating to labor relations and gender affairs and affairs relating to youth and children. That would need to be added as well. So that is something for the committee to consider. What Senator Longmore mentioned as well about having the qualified persons, and I think MP Sibley alluded to it in terms of that, if the tribunal wants expert evidence, the tribunal can call in people and so on. That is something that the tribunal is at liberty to do as well. But to ensure that we cover as many bases as we can do some insertions into the other section. Was it PSOJ or somebody had made a suggestion also that we consider one of the other members to be representative of a civil society. We also would need to consider if that is something that we would want to do. And I just want to address really quickly about the gender balance in the panel as opposed and how the tribunal sits. Okay. So I agree with Senator Longmore that we should focus on qualifications and not gender. Personally, I think that what is there now in terms of 1/2 of the total members appointed to the tribunal shall be females, I think it is fine. Because even though the 12, it's the it's the all-inclusive number representing the total composition of the tribunal. A tribunal will only consist of 3 persons at a time hearing a matter, as is there in the panel in clause 14. And so going back to at least Senator Longmore would like for a female to be a chair. It's for the members in the panel to decide which of their numbers will act as the chairperson, and that person could be male or female. So I don't want us to get very granular where those things are concerned, because it really is a situation where the members will have to decide amongst themselves which of us will chair, depending on so on. So I just wanted to make those few points.
Thank you. And Minister, as best as we could possibly accommodate your guidance in terms and your leadership and demonstration of the dual chair that you have at the gender council, the gender advisory council. Yes. I think that is an excellent demonstration of the gravity of the situation being recognized by both genders. So, if that could be incorporated, that'd be great.
Well, we have been able to balance the scale. And
I agree.
We have been able to balance the scale. And I think the proof is going to be in how we set up the panels when they are hearing matters. But once we have a pool from which we can draw with a gender balance, I think we would be able to achieve what we want to.
So I'm not for the idea of where a submission was made that one of the persons come from
Senator Gale. Senator Gale, I lost you there.
I'm not for I'm not in support of the submission that one of the persons must come from civil society, it being civil society so wide. I am more about having the individuals having the requisite skills and experience. That person may very well come out of civil society. That's right. But to say single-handedly that a person should come from civil society, it does not bring in my mind the surety that that individual who either is selected by the ministry or the minister or a nominee from civil society, how that goes. We have to be clear on that. The rules though, the tribunal to be able to set up its own rules of application is important and necessary. And I don't know if Ms. Grant, that was either contemplated or, suggested, because for clarity in terms of the role and function of the tribunal, apart from, hearing of the issues and making awards and judgment, I spoke about the appointments of the members and what would happen if a member is incapable of serving, the resignation, the reappointment, things like those.
Ms. Grant?
Well, Senator, those things, for example, the resignation, the reappointment, that is something that we'll get to later. But just to say that the vacancies, which is a point that PSOJ made, I believe, that where there are vacancies, where there are resignations, vacancies, however they arise, that the persons who are chosen to fill these vacancies have to meet the qualification requirements in order for them to be considered. Is that what you were asking me?
No, it's not. It's not where for them to come in, you know, is how they operate once they are there, and if they have to leave, if a member dies, if a member has to leave in the middle of a case, if there's incapacity, things like that.
Well,
normally in certain tribunals,
Yeah.
setting them up certain tribunals, there are some established rules that are entrenched in the legislation.
Yeah.
And I just want to be sure that we are conforming to what is applicable in other legislations where we have established tribunals.
Okay, well, the tribunal can make their own rules, but what we have here currently, we have how disqualification is treated. We have how revocation of appointments are treated. We have how vacancies are to be filled, how the membership is going to be published. We have the tenure of office, how acting appointments are treated with, and we also have resignation as well.
I'm seeing
So
it.
I don't know if that.
Yeah, I'm seeing it. I'm seeing it. Thanks.
Right. So it's all here. It's all here, Senator.
Yeah.
All right. So Ms. Grant, you want to, I notice MP Crawford, you there? Ms. Rhoda? MP Crawford, you have been very quiet. All right, I'll ask Ms. Grant to.
You're sure you want to start our up, Minister?
Excuse me, Chair. Noticing Mrs. Celia Brown has her hand up.
All right, Mrs. Celia Brown, could you please?
No, I've seen the provisions, Chair. I was going to make a point, but the provisions are included in the legislation. It's fine.
It's fine. All right, thank you so much.
I just wanted to find out, though, Chair, what, if anything, have we agreed to do with this clause? Are we expanding it? Are we leaving it as it is? Are we considering any of the suggestions made? What are we doing?
Well, I think that the suggestions made here, most of it, we have
not for this clause, not for election.
Into consideration in relation to civil society from those who would be appointed. I'm sure someone will come out of civil society.
What's about the Ministry of Education's suggestion in the other members category? To include
Grant,
after consultation.
All right, Ms. Grant and Mrs. Robinson as critical players in the shaping and further down in the administration of this legislation. What do you think? What is your guidance here? Ms. Grant?
I don't think, certainly, Minister, I don't think that the inclusion suggested by the Ministry of Education would hurt. I don't think it would hurt at all to have that inclusion made in the other members category, which that would be clause 11, subclause 1, paragraph C.
Mm-hmm.
I don't think that should be a problem.
Mrs. Robinson?
Thank you, Minister. So I just like Ms. Grant has said, I have no objection to a recommendation that will improve the way the tribunal will be functioning, because at the end of the day, you want to have the best fit. I also want to say that in terms of how the tribunal is set up and how it will function, we had to have conversations with the Ministry of Labor and Social Security, because they have the IDT, which is where it was suggested initially under a previous iteration of this particular bill. It was requested that the tribunal, the IDT, have a special division that would hear cases of sexual harassment. Based on the fact that the tribunal was going to be requiring quite a number of sittings and so on, it was recommended by the Ministry of Labor and Social Security that we do not have it been in the IDT, but have it as a separate entity. And that is why we are where we are. And so we have been speaking closely with them. We have had meetings with them. so that we will have the requisite guidance, because we do not want a tribunal that is separate from and operates outside of the ambit of a regular tribunal. And we want to have a tribunal that is going to match exactly what is required, because cases of sexual harassment, Minister, as you know, in most cases, sometimes the burden of proof is on the harassee. That's the person who receives the harassment, unwillingly in most cases. And so we want to make sure that the guidance is provided and that we work along with what is there. We've also looked at other legislation in other parts of the country and in other parts of the Caribbean and on the global scene. And we've seen how they have used tribunals to get the kind of redress that is required, because in many cases, the court system is overburdened and sometimes there are long periods where they have to keep going back to court, and the witness or the complainant gets frustrated and then drops the case. And so what we want is the best fit. So we are open to all the recommendations and suggestions as long as the minister is okay with it. All right,
Senator Gale, in relation to this, to the Ministry of Youth Information, Youth Education, Ministry of Education, Youth and Information, what is your take?
Sorry, could you just read that statement for me?
Where they would want to include a representative from the Ministry of Education, Youth and Information, in addition to the Ministry of Labor and Social Security and the Ministry of Justice.
You see, Chair, we can't widen the thing, you know. We have to be specific in terms of the skills that are required, and a tribunal who makes its own rules can also from time to time calling experts for references that would be complementary to the case. Once we start widening it, then others may want to nominate the representative to fit their own requirements.
All right, excellent, Senator Gale. So I think, Ms. Grant?
So we leave it out then, Minister. It's fine as it.
Yes.
Okay.
Yes. All right. So we move on
to clause 12.
To clause 12.
So that clause deals with the appointment of the chairperson of the tribunal, and the only suggestion that was made in relation to this clause comes from Ministry of Labor and Social Security. Their concern is this: if the chairperson has to be a part of every panel, well, this is how they interpreted it. They said it wasn't clear. If the chairperson has to be a part of every panel which hears a matter, you may face the prolonged delay in hearing a matter. And they encourage consideration whether a deputy chairperson should also be appointed, and such a person should also be in a position to chair a panel. I don't get this from my reading of the legislation, but then I have background information. When I read the legislation, what I get is that there is a general chairperson that is appointed for the tribunal in its large form, the 12, but when it gets to the stage of the panel, each panel has a different chairperson.
That's right.
So, right. So what you may need there, Ms. Grant, is an area that specifically speaks to the composition of the tribunal, that establishes the overall chairman or chairperson for the tribunal. And then what the Ministry of Labor would be submitting is that you have divisions now that would have deputy chair for each division. So this chairman or chairperson would not be burdened with the responsibility to sit on every panel or every division of the tribunal, or to hear every case.
I think
yes, Chair.
I think it's clear in the legislation, you know, where it says that there is a chairperson of the tribunal, and then the members of the tribunal present that the meeting would elect one of their number to act as a chairperson at that particular sitting. So in other words,
you know, I don't really like that, and I'll tell you why, Chair. I don't really like that because chairing a panel requires a particular level of skill. And then now, where you're having this skills for respective areas, you're going to have this interchangeability. So the person that is skilled in labor is going to tomorrow morning be a deputy chair. And the person who is skilled in psychology or mediation, as the requirements of the members now, is going to be a particular chair. I am from the strong view that determine who are chair or the chairman for each panel and the overall chairman or chairperson for the tribunal.
So the overall chairman for the tribunal
is someone that is selected by the minister.
And that overall chairperson now can select the panel, or who would chair each panel.
Who would chair each panel, and the chairperson for each panel is consistent.
Yes, so it may be the chairperson for each panel would be drawn from the team of attorneys.
It can be drawn from anywhere. It could be drawn from the team of attorneys, but it could be drawn from anywhere. But it's consistency.
So the chairperson of the chairperson overall of the tribunal would determine the panel and select the chair.
And select the chair.
Minister, I see Mrs. Seeley Brown and Senator Campbell took her hand up.
I'll go to Mrs. Seeley Brown first and then to Senator Longmore.
Thank you, Chair. Chair, through you, Chair, Senator Gale, if you look at clause 14 of the bill, it is clear that the tribunal, well, first of all, you're not having divisions because you're going to have hearings that have been, the hearings will be heard by a panel. But it says in clause 14, subclause 2, at least one member appointed pursuant to subsection 1, which is where you have your panel being appointed, shall be a female, and another member so appointed shall be an attorney at law and the chairperson of the panel. So that is where it's clear that for every panel that you're going to appoint, you're going to have a specific chairperson. And it goes on, Senator Gale, in subclause 3 to say that in assigning members of the tribunal to a panel, the chairperson shall take into consideration the requirements, if any, for experience and expertise to enable the tribunal to decide the issues raised in any matter before that tribunal, meaning that the same thing, the point that you're raising, if you may need a particular type of expertise for a student who has brought a complaint as opposed to an employee. So I'm thinking, Senator Gale, that what you are querying may well be covered in clause 14 of the bill.
So, so clause 14.2 makes the designation strongly that one must be a female and another so appointed shall be an attorney.
And the chairperson of the panel.
And the chairperson of the panel should be an attorney also.
Yes, so yes.
There's 2 attorneys you have plus a female. So the female can be anybody.
Yes, but the person who chairs the panel must be an attorney at law.
Must be an attorney.
Yes.
And
yes.
you want another attorney on the panel. So there have to be 2 attorneys.
No, it says at least one person appointed shall be female. Yes. And another person so appointed shall be attorney and chairperson. So you may have the other, you have the other person who may be that person with the expertise that is required for that particular tribunal.
And bear in mind, Senator Gale, the attorney appointed to be chairperson could also be a female.
Yes, that's a given.
Yes.
That's a given, you know.
Yes.
The safest bet going through this window is the female.
Thank you.
I just want to be satisfied that when a matter is being heard, it has the requisite skills and you see, Member Sibley's had mentioned that you have tribunals with all female that he has seen. And tribunal don't necessarily mean 3.
No, it doesn't.
A tribunal is an institution.
Yeah.
Well, Senator Gale, if you will notice in this meeting, between the technical staff, the technical team, and the members of parliament, the men are and senators, the men
No,
are.
there's a major gender imbalance.
And it
Member
was
Siblings and myself have recognized that from day one.
but it was not deliberate. It's just, you know, that is the nature of the beast. You have to accept that.
we by no means are we complaining. We just mismember with her today.
Yes. All right, so Ms. Grant, I think we can move on.
Yes, Minister.
Thank you. You're doing an excellent job.
Thank
Ms.
you,
Grant, cut out
Minister.
for this one.
Chair, I just wanna remind you. No, it's okay. I just wanted to sneak in the point again of your approach to the Gender Advisory Council, of the overall chair.
Yes.
And the chairperson having a co-chair situation reflecting both genders.
Yes.
And I think that as we're dealing with this issue and the public's perception, because you know, the men in the society are gonna go say, well, you see, they are think some know, you know, how that will go. I think it will be really a monumental thing, as you have done with the advisory council, to probably have a similar thought here. So
yes.
just throwing that in there for your thoughts.
Yes.
Well, Senator Longmore, you can imagine when alleged perpetrator appears before a panel that is all female.
Well,
I can imagine.
Senator Gale.
Yes, Minister.
Senator Longmore is highlighting the fact that I have a National Gender Advisory Council, and I won't tell you that the composition is mainly female, just so happen to be so. But at the leadership level, I chair, and I have 2 co-chairs, 2 co-deputy chairs. I have a male and a female. So I try to balance it in terms of the leadership, set that example. So I just want to reassure that we are not going to be, we of course have to recognize the imbalance that exists in society and work towards empowering our women. But we also have a responsibility to ensure there is some gender balance, some gender equity, and that we don't leave our men behind.
Yeah, thank you.
Yes, thank you. Ms. Grant?
Yes, Minister. Okay.
Yes.
So we're on to clause 30 now, which deals with the jurisdiction of the tribunal to hear complaints. And the Ministry of Labor and Social Security proposed that section 13(1)(b) be reviewed to determine if a reference should be made to, well, it would be clause 4(3)(f) or clause 4 subclause 4. All right, so what is here is, subject to the provisions of this part, the tribunal shall have the jurisdiction to to be a complaint made by a person in relation to hear, well, a complaint made by a person in relation to any matter arising under section 4(1)(f). So when you go to 4(1)(f) now, 4(1)(f) says, well, it would now read, well, we had discussed what 4(1) would be, but let me read what is here. Subject to subsection 4, every employer, 4(1)(f), give me a moment here. No, sorry, 4(3)(f). So
4(3)(f).
Right, so 4(3)(f) says the policy statement required under this section shall provide for the following. And F says a statement to the effect that the employer or person in charge of the institution shall not disclose any information relating to a complaint or the circumstances of a complaint to any person, except where the disclosure is necessary for the purposes of investigating the complaint or taking disciplinary action in relation to the complaint. Or they suggested 4.4, which says an employer or person in charge of an institution who discloses any information relating to a complaint or the circumstances of a complaint in contravention of 3F shall be liable for such disclosure, and a complainant who is aggrieved by such disclosure may make a complaint in respect thereof to the tribunal. So what is here, 13.1b has 4.1f, but then there is no 4.1f. So they are saying you only have 4.1a and b. So they're suggesting that probably the reference should have been 4.3f or 4.4.
It is really 4.3f. But there's no 4.1f.
No.
It's 4.3f and 4.4. They're correct.
Right. So
Yes.
So this is the disclosure about the people and personal information.
right. 4.3f. A complaint. Okay.
Sorry, Chair.
Yes. Go
I'm
ahead.
thinking it should be 4.4 because 4.4 is where the contravention lies rather than 4.3f, because 4.3f just speaks to the fact that the policy should have this statement saying that you shall not disclose, but 4.4 creates the contravention in respect to that disclosure. So I'm thinking
it is where the disclosure actually takes place.
yeah, but it say, you remember, it's a complaint. It says an employer or person in charge who discloses any information in contravention of 3F. See, it tags it back to 3F, shall be liable for such disclosure, and a complainant who is aggrieved by such disclosure may make a complaint in respect thereof to the tribunal. So the liability comes under 4.4. So I think we should peg it to 4 at 3F.
4.
On page 7 of the bill.
Yeah.
It's 4.4. Yeah. Okay, good.
So that's 4.4.
Yeah.
All right, so continuing on from the Ministry of Labor, they said, how will the panel make a decision after hearing a complaint? Should it be by voting? Should the decision of the panel be made by the majority of its members? What obtains if there is a deadlock? Should the persons chairing make the decision if there is a deadlock? So things for us to consider there.
So,
Yeah,
yeah, no, Mrs.
sorry,
Seeley,
sir.
Go ahead.
Yeah, I think those are things that ought to be included in the legislation.
Yes.
Provisions relating to how whether the chairperson should have a casting vote. Yeah, I think those things the committee may wish to consider including provisions of that sort in the legislation.
Well, if that is your recommendation, we would certainly ask you, yes, to ensure that
what you want to ensure in this scenario, Chair, is that having heard a dispute, you want a resolution.
Yes.
And the question of a deadlock on if the panel is a 3-member.
A deadlock?
The question, they made reference to a deadlock. They made reference to a deadlock.
Yes.
Unless the chair has no position. What I've seen is where 2 members might agree on a particular position and you have a dissenting voice, which may cause that individual, that member, to so put it in writing. And they may have that right.
May I say something here?
One sec, MP, Senator.
But I also believe that these provisions, as Mrs. Seeley Brown has indicated, must be outlined in the legislation so as not to put the legislator, the tribunal into disrepute.
Yes.
And so you won't have a situation where a party then challenges the ruling of the tribunal, because they would have to challenge on a provision that is contained in the based on a provision that is contained in the legislation.
All right, Senator Gale, thank you for those points raised. I'm going to ask MP Sibley's to now make his comment. Go ahead, MP.
Yes, Chair. Just I wanted some clarification. Is it that the deadlock comes about because there's a 4-member panel? Ms. Seeley Brown? Mrs. Seeley Brown?
Is it a panel of 3, including the chair, or is it a panel
I
of?
think no, from my reading of 14, clause 14 to chair, it's a panel of 3. Yes, and 14.1 says that. It says the complaint made to the tribunal shall be heard and determined by a panel consisting of.
It's 3. It says 3.
Yes.
I just wanted to make a correction, Chair. Since I have the floor, to the same clause 13 that we are looking at. Where there is a paragraph B, that should really be a subparagraph 3 in paragraph A. So it should read here and determine 1, 2, and where there is B, that should be a 3. And where there is C, it should be B, because it doesn't flow as it appears in the legislation now, Chair. It would read here and determine paragraph 1, a complaint made, continue, a claim instituted, and then 3, a complaint made by a person in relation to any matter arising under section 4.4, which we just corrected, 7, 8, or 9, and B, make any of the awards specified in section 34.
Okay.
Noticing it, Chair.
Okay, thank you. Thank you for the correction there. Yes.
And Chair, Mrs. Aldred's hand has been up for a while.
Yes, please go ahead.
Thank you, Minister. I don't agree that we need to put something in to say that the chairman has a casting vote. There are 3 members. There's no need for a casting vote.
Right.
There can be no deadlock. That would only arise if you had an even-membered panel. With an uneven member panel where you must have 3, so you can't have a 2-member panel. The law doesn't allow for it. The law says a properly constituted panel comprises 3 members. A deadlock cannot arise. So I don't agree with us putting something in to deal with a situation that cannot arise. But I mean, granted, I'm just giving advice to the committee for your consideration.
Sound advice, SG, sound advice. You can't have a deadlock with 3. Members, in relation to that recommendation, we have a panel of 3, so we can't have a deadlock.
Yeah, that's understood, Chair.
Yes. All right. Miss Grant?
Yes,
Please.
Minister. Still on the same clause 13. One of the complaints, well, one of the suggestions made is that earlier suggestion that there is consistency in language. And Mrs. Seeley Brown, I'm looking at this clause 13, and 13.1a has here and determine a complaint, A1, and then A2 has a claim, and B, which should rightly be 3, has a complaint. So we have complaint and claim. And one of the things was about using the consistency.
Yes, we should, sorry. I should have addressed that also because it was brought up earlier. It should be a complaint because that's what is defined in the clause of the bill. So just to make the language consistent, I totally agree.
All right, so that's a matter of just tidying it up, right?
Yes, Chair.
So just to clarify then in subclause 2, in terms of coverage of those who are in scope. It speaks to the student, and the resident treats with the tenant-landlord situation, the ward or inmate, patient, or a member. I suppose the member can treat with the institutions like the church or so, or any of those groupings that requires membership. And as the case may be of an institution that the person in charge of the institution has failed to act. I just want to know that we cover all, since we start dealing with specifics, that we cover all possibilities.
Yes, Senator Campbell Rodriguez.
Thanks, Minister. 13.2, the
Senator
same,
Gale.
the
Go
same
ahead.
section referred to by Senator Gale. I don't think resident there can be interpreted as a tenant because it says of an institution. And when I read it initially, a resident to me meant someone like in a children's home or something like that. So I don't think it would cover tenants. So we need something specifically to cover.
I am seeing that now, of an institution.
Right, so we have to put
So
something
all
specific.
of them speaks to an institution.
Exactly. That's my reading of it, my non-lawyerly reading of it.
So the first one speaks to the worker in the employment, and
Yes.
the other speaks to the institutions.
Correct.
So there's nothing that speaks to the tenants, landlord situation.
That needs to be added, I think.
I want a glasses like yours.
I can tell you where to order it.
Yes, Mrs. Celia Brown.
Sorry, no, actually,
Just give me,
I was going to say it's there.
I think they fall under 3. On the particular
9.
section.
They fall under 9. So it's there.
They would fall under 9, Chair.
Remember that Mrs. Celia Brown asked for an amendment in terms of what's before us in the bill.
Yes.
So A should have a 1, a 2, and a 3. What's in B should really be 3. And in 3, it talks about the complaint arising under a number of sections, including like section 9, that deals with the person in the accommodation. So it would be captured under 3.
Correct.
We've changed B to make it A3. It will become A3.
Member Rodriguez still
hear the complaints.
Muted, Senator. Senator, you're muted. Think you're speaking?
Okay, thanks. So you're saying it would a complaint made by a person in relation to any matter arising under 4, 7, 8, or 9?
Yes, because 9, Senator, if you look at clause 9, it deals with sexual harassment in relation to accommodation. So that would be your landlord, tenant, person who is boarding, all of those relationships.
All right.
Captured on the clause 9.
Okay. All right, great. Thank you.
Yes,
The reference in B captures it.
Yes, sir.
Yes. Okay, great. Thank you. Ms. Grant?
Yes, Minister, I am here.
Yes.
All right, so that would take care of clause 13. So we would move on then to clause 14.
So may I have the decision of the committee as it relates to clause 13? Any change?
Yes, SG. We were changing, apart from the amendment that I proposed to the subparagraphs 1 and 3, in subparagraph 3 as we numbered, rather than 4.1F, it will be 4.4. 4 subclause 4.
3F, it will be 4.4.
Are you going to change?
Thank you. No other change there.
And I'm sorry, Chair. And remember, we are going to be consistent in our language.
Yes.
So in subparagraph 2 of paragraph 8, we would delete the word claim and substitute complaint.
Complaint, right.
Okay.
Okay.
Thank you.
Thank you, SG. Thank you, Mrs. Celia Brown. Mrs. Grant?
Yes, Minister. So clause 14 deals with the hearing panel of the tribunal. And Ministry of Labor says in relation to 14.2, and 14.2 says at least one member appointed pursuant to subsection 1 shall be a female, and another member so appointed shall be an attorney at law and the chairperson of the panel. Okay. So they say that it appears that the panel of 3 should consist of a female, an attorney at law, and the chairperson of the panel, who is also an attorney at law. It's not clear if the clause states that another member is to be the chairperson who is also an attorney at law. And so they encourage that the clause be revisited to ensure that the meaning is clear. They said if the former is the intent, that is a female attorney at law and the chairperson, the presence of 2 attorneys on each panel will reduce the role for the persons who are selected under section 11.1b and 11.1c, unless these persons are mostly female. I don't particularly agree, but okay.
I don't
May I
know.
share? May I share?
Yes, please do.
Yeah, but it's clear because it says it's at least one member appointed. So you have 3 members, one shall be a female and another shall be an attorney at law and the chairperson of the panel. I think it's clear, Chair.
I think it's clear too.
I agree. But
yeah, I think it's clear. Members, anyone wishes to comment on this? I think it's clear. So
I think it is clear, Chair.
Yes.
If the lady said it is clear, it is clear.
That's a gentleman.
The ladies, gentlemen.
Okay.
Do I have to protect ourselves?
I have seen you batting well, Senator Gale.
Senator Gale is doing well. You're not doing badly.
You're the lead batsman, yeah? I'm keeping the crease. Well,
yes, Ms. Grant?
Okay, continuing on, Minister. So we're at clause 14 now, which deals with disclosure. Sorry, 15, I beg your pardon. Disclosure of interest in relation to matter before the tribunal. This suggestion is from the Norman Manley Law School, the only suggestion in relation to this clause, and it's dealing directly with 15.2. 15.2 reads, a notice given by a member, let me read from the top. A member of the tribunal who has an interest, whether directly or indirectly, in any matter brought before the tribunal shall so. Then 2 says, a notice given by a member at a hearing of the tribunal to the effect that the member is interested in any matter before the tribunal shall, for the purposes of subsection 1, be a sufficient disclosure of the member's interest in relation to the matter. Norman Manley Law School said they are proposing in relation to 15.2 that a notice by a member who has an interest in a matter before the tribunal be served prior to the hearing of the complaint, so as to avoid delay in the commencement of the matter. If this is done, then another member might be appointed to replace such a member who has given the notice under this section. That's the only suggestion that was made relating to clause.
My concern with this, if there is an interest and that interest becomes or appears conflicting in nature, is it just that you're going to serve notice?
No,
There's
Senator, look
section
at
B,
15.1.
Senator Gale. That's a
Look at-
distinct
yeah.
part.
Look at
Section
1.
B, Senator Gale. Look at
Be
Part.
not
B.
not take part in any deliberation or decisions of the tribunal with respect to the matter.
That's
So
right.
so what that grouping is saying is that before the matter is heard, you serve notice and then you recuse yourself.
That's correct.
Okay.
Well, this doesn't say prior.
Well, that's what they are saying, that it is not outlined that it's done prior to.
Yes.
And it looks a little chaka in my mind if you do it at the commencement of the hearing. Do it before.
Yes. So can we insert that?
Or using the term untidy.
Yeah. Yes.
Senator Chair,
yes.
through you, I agree with the law school proposal that any member of a tribunal who would see where there's conflict of interest should declare beforehand. But I don't see this clause saying that preventing a member of a tribunal, any member of a tribunal who would have known that there's conflict of interest, not to clear him or herself. But and so maybe out of abundance of caution to put it there, but I see nothing with the bill as it is currently proposed. You know, I think we could, I just don't. I see for every tribunal, every court that tribunal or member of a court is aware prior to, he or she would have given notice. But if at the tribunal, while the tribunal, even in the first hour or within a day, that the person becomes aware, because sometimes in these matters you wouldn't know. So I would accept what the Norman Manley Law School had said, but to leave this as it is as well.
So Chair,
I the comment of the experts, the technical team.
Mm-hmm. All right, Senator Gale, thank you,
Chair,
MPC Bliss.
Chair, let us determine how this awareness can present itself.
Mm-hmm.
Because in the Industrial Disputes Tribunal, a member becomes aware of a matter when the matter is presented to them by one, the terms of reference that has been reported, and two, the brief submission that would have been submitted by parties. That's how they become aware. And so that would give them advance notice in terms of the issue itself. And so we have to make a determination as to what triggers this awareness to be fair and reasonable to the members.
Mm-hmm. All right, Senator Gale, but it says here that by notice disclose the nature of the interest at a sitting of the tribunal. And what Norman Manley's recommendation is that they should declare that prior to. Am I right?
Yeah, but so in here it says at a sitting.
Yes.
Norman Manley Law School is suggesting that do it before.
That's right.
So if you were to do it before, then you would have to be aware of the matter that give rise to the conflict of interest before.
So therefore, when the chairperson, the overall chairperson is putting the panel together and so advise the persons here selected, then those, whoever has a conflict of interest would so declare.
But they would have to be aware of the matter.
Yes, but I think they would have to be aware of the matter if they're going to be appointed by the chairperson, the overall chairperson, before they actually sit. Well,
and that interest may also include the chairperson.
Yes. So you would have to recuse himself. We see
It's just a matter for me. It's just a matter for me, Chair, as to the appropriate time that that member becomes aware of the issue, so as not to create
a delay.
A delay on the one hand, and yes. I don't like the idea where it is at the hearing itself. You have to recuse yourself.
Let us seek some guidance here from the technical team. Mrs. Celia Brown or the SG or someone else from the team?
MP Davis.
Yes, MP
has
Davis
raised her hand until it becomes tired.
Yes,
thank
MP
you very
Davis,
much.
and then afterwards I will ask Mrs. Celia Brown to comment. Go ahead, MP Davis.
Thank you, Chair. I don't know whether it is by design or default that 15.1 speaks to a sitting and 15.2 to a hearing. And I think if we were to make a distinction, it would address what Senator Gale is saying, that at the time of the constitution of the tribunal, when I imagine that it is just being decided that there is this complaint that has been brought and the tribunal has been selected at that sitting perhaps, then you can then disclose your interest. That is before there is a hearing. So I guess what I understood Senator Gale to be saying is that at the time of the hearing, you would have already known what the issues are and who the parties are. But you can't know before, you can't disclose before that. I can't, by virtue of being a member of the tribunal, disclose an interest and the matter has not yet been brought. It just seems to me to be more logical that the tribunal has been selected, that is a three-member panel, and at that first sitting where it is disclosed what the issues are, who the parties are, at that time the member can indicate that there is a conflict. And then at the hearing, that person does not have to be present. And at that time, the chairperson would have had the opportunity to make a substitution. I mean, that is the only way I could reconcile it, having seen the difficulty myself. I don't know if that was the intention.
Or maybe at the sitting, the chairperson would indicate the matter. Interest would be declared at that point, so that in appointing the tribunal for the hearing, that person would not be considered.
You agree with me, therefore, that either part, whether it's at the hearing or the sitting, either one is going to create a delay?
Not necessarily.
Why?
Because if at the sitting is not to hear the matter.
Yes, but the sitting starts the matter.
Let us be advised now by Mrs. Celia Brown. Go ahead. Thank you.
I'm noting the concerns, Chair, but can I be given some time to look at it again before I comment, so we can come back to it?
Sure.
Yeah, I just need to clarify in my mind.
Okay.
I just want to advance what I consider to be a progressive approach in terms of the notification to the members before you empanel what the brief constitutes, what the matter constitutes. So that's what I'm trying to prevent, is having that taking away of a panel member in the appearance of the disputing parties.
So you would say then the notification would advise on the matter that
yes.
is to be discussed.
Yes.
At that point, anyone who has a conflict of interest would so advise the chairperson to say, I'm unavailable to be at this sit.
Nobody needs to know that there's a conflict of interest in either disputing parties. And you have to take into consideration also that in the magnitude of this issue, when parties appear before a tribunal, there is already a level of impatience of the matter being heard. So to come to appear or to be heard or for a sitting and for that to be postponed because someone has to recuse themselves because of a possible conflict of interest, it's something that we need to avoid. But I know Mrs. Seeley Brown is going to take some time to take on what I would have represented.
I see the Solicitor General wants to make a comment. We come back to you, Mrs. Seeley Brown. Go ahead, SG.
Yes, not that I have the answer, but hearing everything that has been said, I think we'll also have to take into account clause 29(1), and in particular, to look at the timing of when, for instance, the file of the hearing is actually given to the tribunal members, because you wouldn't know before. You're not going to know the details. You're not going to know anything before. The names, just knowing the names of the parties may not disclose the actual conflict. It could, but it may not. But certainly when you get the file of the hearing, that is when you should be aware of a conflict. Now, I'm not sure of the timing of all of this. I think that is something we would also need to look at when considering the matter. And I do agree that some time should be given to just consider the sequence and ordering of events. And perhaps we could then report at the next sitting of this Joint Select Committee meeting.
Thank you, SG. Mr. Seeley Brown?
No, Chair, having heard what Mrs. Aldrich said, I would need some time to just look at it again and see.
Right, to come back with the sequencing and what the recommendation should be. Okay, excellent. Ms. Grant?
Yes, Minister, I am here. Okay, yes. So that takes us to clause 16.
I'm sorry, Ms. Grant. If you're going to be moving ahead, Mrs. Masada had an issue on an earlier clause. So if we could, if Minister, if you would be so minded.
Yes, please. Mrs.
Thank
Masada.
you.
Yes, please go ahead. Yes, please go ahead.
Mrs. Masada, I think you need to cut your video because I think if you cut your video, we'll be able to hear you.
Except that we know you're on television.
Minister, I think the problem is her bandwidth. There seems to be an issue.
All right, she can go ahead and make her point. Go ahead, Mrs. Masado. All right, what we can do, Ms. Grant can continue.
I think I actually, Chair.
Yes, go ahead, SG.
Minister, Minister, if you don't mind, I think I know the issues that she was going to raise, and it was in relation to, can we just know what the decision of the committee was in relation to clause 11? Because there was discussion about including someone who has expertise, I think, in mental health area. And as far as we recall, no change was recommended to the clause, but if that was agreed, then you would need to make an amendment to the clause. I think there was some discussion about having a clinical psychologist or mental health professional on the panel, but I don't know what the decision was. So we just wanted some clarity on that.
Yes, I think members, from what I recall, I think we all agreed more or less for to include someone there, but a mental health.
Would it be tidy up? Would it be tidy up, Minister, for the four persons that would be included here, that we just spell them out? In other words, it says labor relations. You want somebody for dealing with gender affairs. The psychologist.
Yes.
So to be clear, is this each panel?
No, this is the entire composition.
The entire composition.
Yes.
So when
the entire all the members should be four attorneys, four trained persons in mediation with at least 2 years experience. So that's 8. So the other 4 now would be labor, somebody with gender affairs, the psychologist, and
Madam Chairperson and Senate, I think no, I could be wrong and I stand to be corrected, but several of the certified mediators in Jamaica, from my understanding, are also lawyers. How do we ensure that in addition to the 4 members being attorneys at law, the other 4 or even 2 don't end up being more attorneys at law? We have to ensure that that does not happen, because even though it's a legal matter, it's also more of a gender issue. And we just have to be careful we don't end up with a panel with 6 attorneys at law. I support that we need to have that mental health person, for sure. I didn't hear anyone object to that one. But I'm also, again, placing on the table my call for someone from the Employers Federation or the PSOJ to be included on the panel.
Mrs. Robinson.
That would be the other one for me, Member Rodriguez.
What does that mean? I didn't hear you.
The person from the employer, representing the employers.
So we're speaking of
the labor person.
Yeah.
We're speaking of someone representing the employers, and we're speaking of a mental
health, and the labor person has to be there.
So it's labor, mental health,
employer,
gender, and employer.
Yes, and I want to reiterate that we need to find a way to cap it so that we don't end up with the mediators also being attorneys, because that is a great possibility, because many mediators in Jamaica are attorneys.
So in that case,
sorry, there's a way to do that though, where you can put it in B, that the persons who are trained certified mediators shall not be attorneys. You
shall not be attorneys.
Yes,
you cap the attorneys.
Yes, because that would cap the attorneys.
But as an attorney, I'm not fighting against people in my own profession.
Right, you can tell them it's me.
Not to complicate things, but may I ask a question here?
Yes.
When the panel deliberates a particular matter, a particular case, and because if we have only one mental health person, I think we have all, and I think everyone recognizes the importance of having that level of input and that expertise. When we have a panel, if it is only one psychologist on the tribunal, and that person is not on a panel that is only 3 persons, how do they get that level of expertise? And not just for mental health now. The other singular backgrounds that we are considering, not we have the attorneys being covered. But my question is, when if the panel comes up with a verdict or come to a conclusion on a particular case, is that final, or does that go back to the entire grouping of the tribunal for further deliberation before a final outcome is determined. Because what I'm trying to ensure is that we have the input of all of these professionals, because we don't have enough on the panel for each, on the tribunal for each panel to have that level of expertise.
But Senator, sorry to cut you, but not
Sure.
every issue will need the specialist people.
I
So
understand
that is why.
but
So for example, not everyone will need a psychologist. Not everyone.
It is very hard. It is very hard for me. No, that's what I'm saying. And the reason why I relate to that, and not because of my predisposition to the whole mental health agenda, but it is recognized by almost every group that made a submission to us. It is recognized within this central group here that a mental health professional would be the input of that person is critical. So, you know, my general question is not even around that. It is whether or not, when the panel comes to a conclusion, is that the final say, or is there a overview from the tribunal at large?
All right, Senator Longmore, it would be a final decision of the panel, because they would be the ones who have heard the evidence, and that is the scheme of this law.
Right.
They would be the ones to hear and determine the matter and make a finding.
Okay. All right.
Senator Longmore, I'm
yes,
thinking
please.
that the panel would have the flexibility or be in a position to draw on expertise and skills during the hearing. I don't know. SG, that's something that the panel would be able to do?
So I think the thinking of the constituting the panel, the way it's set up, the thinking would have been that you would have had your chair, which is the attorney at law. You're going to have a mediator. And then depending on the matter, when you're selecting the panel, you would see from what is presented, whether you think you need the person trained, the medical health professional, or if you need perhaps someone who is more qualified and experienced in labor social security matters, or in gender affairs. So it's at the time when you select the panel that you would have determined who goes on that panel from that grouping of 4. I think that was the thinking.
Sorry, can I ask a question through you, Minister?
Yes.
Because I'm wondering why it is that we have compulsory 4 attorneys on the panel. Why is it that we have 4? Because to be honest, I don't think we need 4. We probably could have split that to 2 mental health persons and 2 attorneys.
So I think the issue was that you could have 4 panels. So if you're going to have 4 panels, you would be able to have an attorney for each panel. You would have had a mediator for each panel, and then you had 4 others that you could select from. I think that was the thinking. Because it can't change, but I'm just saying I think that was the thinking.
Right. Remember, each panel has to be chaired by an attorney.
But it couldn't be that one attorney chairs 2 panels?
No, because you may have a situation where all might be detained hearing matters.
Okay.
So you have this situation
sitting at once.
Sitting at once. So you have the situation where, because of the splitting of panels into 4, or the divisions into 4.
Right.
So you have the mediators, because the mediators for this, these matters might be so challenging that you want persons in there who have a calm mind,
emotional
a reassuring mind, the emotional intelligence. And so you deal with the first 2 subsets.
All right, I get it.
And then now, to identify particular skill set, you want the labor relations person,
employers.
Dr. Longmore, Dr. Sophia Longmore has argued very vociferously to include the mental health person, as she normally does. You have the labor relations person, that
The gender person.
I would have to defend, and you have the
gender
gender person. So that's 3.
And I had suggested someone from the Employers
and
Federation.
no, some grouping made reference to the HR person, but you want somebody who understands the ins and outs of employee, of being an employer.
Right.
So that's where the employer comes in to ensure that there is a balance. Because on most of the occasions, you're going to have these work-related matters coming forward.
To have them.
Yeah.
We have to have some.
So that is the real breakout in terms of the composition.
An employer representative, mental health, labor relations.
And gender. Oh, hold on. Employer, labor relations, mental health, gender, that's 5.
Mm-hmm.
Okie dokie.
So what do we
this
say?
This is where the chairman now has the casted vote.
Can we, Madam Chair, before you cast your vote, and you know we love to vote. Question, we not, because we see the reason for all these persons, right? Could we not make it a 13-person panel, tribunal, instead of 12?
Oh.
I lost you there. You're saying instead of 12, we should increase the number?
To 13, just because we have made the case for all the persons we have mentioned. And so make it a 13-person panel instead of a 12.
You may have a situation in that where one person always might be floating when all other panels are detained.
Chair, remember, there's also another factor that we had clarified in the before, that whatever expertise that may be needed,
that's right,
the tribunal can access. So I think that also helps to deal with the situation.
Not really in this case, because which expertise would you pull off? You always need that employer rep. You always need that labor rep.
External to the tribunal.
No, but we're talking about the tribunal, and I'm saying which one would you take off? Because now we're at 13.
But let me ask Mrs. Robinson or Miss Grant, you may want to comment in relation to the tribunal being 12 or being 13 as opposed to being 12 or being 14 as opposed to being 12. Miss Grant, Mrs. Robinson, who wants to take this one? Yes, Ms. Grant.
Chair, I would leave this to Mrs. Robinson to comment on, while I look for other iterations of the bill.
Yeah, Mrs. Robinson.
Thank you, Minister. So this is interesting. The thing is, with the numbers, I think we had so many conversations around the composition of the tribunal and how we wanted it to be nuanced so that we would have the balance. I think part of the reason it ended up being 12 is because of the breakout of 4, 4, 4. And then we thought the 12 would be, as I think somebody mentioned earlier, that at least 3 members would be at each sitting. And we also thought of making it across Jamaica, so that unlike the IDT where the sitting is only in Kingston and St. Andrew, we would want to make it accessible to persons who are out of town as well. So we wanted to have simultaneous sittings. So I think it's more about the reach and trying to make it accessible. That's how we arrived at the 12, because it was actually less than that. And I think the minister made a case to say, make it as broad as possible, as accommodating as possible, to make sure that everybody is covered and captured and there's no discrimination.
So would we have a difficulty if we increase the number to 14?
No difficulty, Minister, because we're trying to get the best fit, and we want to make sure that at the end of the day, what we do is not leaving anybody behind, and it gives exactly what we want. I have no objection.
And that it's representative of, across the island, and that we can have several panels sitting at the same time,
Absolutely, Minister.
Yes. So members, first I should get the opinion from our technical team if we were to go to 14. If you see any problems there, any issues?
Minister,
No? Yes, go ahead,
Minister,
Mrs.
before the technical person comes in, may I just put the suggestion out there so that if there's a problem, someone from the technical team can tell me, no, that's not acceptable. Since we're going to 14, can that 14th person be at the discretion of the minister? Let me tell you why. And I know you may be in a strange position to say yes to giving yourself more power, but I would say that sometimes we don't think about a certain person or a certain specialist that may be needed. And, you know, when the tribunal is being put together, that 14th person, because we already filled out the 13, that 14th person could be at the discretion of the minister rather than the legislation dictate, you know, than us dictating what that person should be. Just a suggestion.
Go ahead, Mrs. Seeley Brown.
I just wanted to clarify what Senator was saying. Is it that you're saying that that person should be any other person so appointed by the minister? So you leave the qualifications and everything for the minister to determine?
Yes, that's my suggestion.
I've seen that in other legislation, Chair, and I mean it's a policy decision as to whether you would expand the numbers. That is not something that, you know, would affect anything in the legislation that we, the technical people, will be able to guide you on. But and I have seen that construct where he's left to appoint somebody at his discretion. So that also can be done.
So Senator, what are you saying? 14 plus giving the minister.
So the 13 that we discussed, and that 14th one being at the discretion of the minister.
I would say 14 as the
yes.
overall tribunal, because we're trying to divide
yes.
the gender.
Right.
And if you're saying that we should consider now another person based on skill or expertise that may be required for a particular sitting.
No, what we said, Minister, sorry to cut you, is we had come up with 13 already. And then you suggested that the tribunal be 14. So I'm saying that 14th person could be your discretionary. And by you, I mean the office of the minister.
Instead of naming the areas.
Yes, for that 14th person, because we already have the 13 named already, areas. And so that 14th one could be at the discretion of the minister.
Ms. Grant?
You could do that, Minister. You could do that if you so desire. If you are going to do that though, Minister, you probably might. Okay, maybe you'd want to do after consultation with all the persons that are, all the ministers that are listed as we have it now in C, 11.1C. But you could do that as well as you could elect not to.
SG? Thank you, Ms. Grant.
My comment is not so much a legal one. It's more from a actual practical experience where we have had legislation going forward. And in the Senate, we have had an issue because the concern usually is what guides the minister to make that decision. So we have put that kind of construct before because we also can see value sometimes in being too restrictive, but we have had to change that more than once, Senator Gale, because of discussion in the Senate that there should be better guidance to the minister. You don't want the minister to run amok. You want the minister to be guided and to act. Now, my response from a legal perspective is Wensbury's principles. A minister must act reasonably. So within the construct of what is being done here, you wouldn't expect the minister to appoint someone that could bring no bearing in discussing and determining matters like this. But I'm just saying we've had issues in the past. So I'm just coming from that perspective. Legally, there's no problem with it. It doesn't offend any legal principle as far as I know, but I just know that we have had issues in the Senate before when we have tried this kind of construct.
So that's why I was suggesting, SG, that if that is accepted, that the minister doesn't do it on her own, but with consultation with other ministers in the various other areas.
Well, the more complicated we make this thing, you see, the longer it will take to arrive at any decision.
So let me just go a little further just to say that just because I have raised an issue doesn't mean it can't be done. It just means you would have to have your justification. So you have a justification for having that 14th person being left to the discretion of the minister, and you put forward that justification. But I'm just saying you'd have to make sure it is a strong justification and your members of your committee agree and will support it.
The good thing is the minister didn't suggest it herself. It came from one of the senators. So I don't know. I would love to hear what my colleagues think on it, if Minister Grange, if you will allow.
Senator Gale, and I'd like to hear what the MPs have to say too.
So Jen raised the point that this matter would have presented itself on not one, not two. In fact, I recall that most often when the minister is to utilize their discretion on appointment, it is always a cause of concern because it appears that you are giving too much authority to a minister. I have never raised that concern, let me declare, because I fundamentally believe that the minister should be given that level of authority. And a minister can only demonstrate the responsibility if they are given that authority. Okay, having said that, I don't have a difficulty with it. And I'm also seeing a situation where we were on the verge of a dispute and a compromise has been extended by saying, let's move it to 14. So what is wrong with what is contained in C that suggests that if you want the person for this experience, that minister can consult and the consultation takes place so that it removes the appearance that the minister did it on their own. So in this time, I'm quite satisfied with where we are now. And if it gets to the stage when this bill comes before the Senate, I am prepared to defend it. It's not a time for you to be muting a minister.
That wasn't deliberate. Senator Gale, thank you for your comments, and thank you, Senator Campbell Rodriguez. We have any comments from MP Davis, MP Sibley's, MP Crawford has been very quiet. Senator Gabriela Morris, any comments from anyone else? Go ahead, MP Sibley's.
But I consider minister the legislation act asking minister the power to name a member of the tribunal, the 14th member of the tribunal, because situation can arise within a that would give rise to the minister use her discretion in making an appointment of a certain qualified person that would fit the situation that may arise. So I am in agreement with the Solicitor General in that ministers ought to act reasonable, and ministers ought not to make decision based on emotion, and it is within the it's a discretion that must be grounded in at all times. So on that basis, I would support it.
Okay, so anyone else wishes to comment? What if, all right, so if we were to say that the tribunal shall consist of 14 members, 4 who are attorneys, 4 trained and certified mediators who have each practiced for at least 2 years.
And are not attorneys.
Okay. And they're not attorneys. Do we have to say that? They draft
because a lot of the mediators in Jamaica are attorneys, and then we could end up with a tribunal with too many attorneys.
And then the other members shall be selected from among persons who, you know, for labor and social security, for in mental health, gender affairs, and which was the other, and from among employers. And then we just leave it at that. And then we can appoint 2 other persons where we consider it important to draw on those skills. For the drafters, please guide us. Ms. Grant? Can we increase the numbers? We increase the number to 14 and list other areas in which we would like to see those skills or expertise included on the tribunal. Ms. Grant? Or go ahead, Mrs. Seeley Brown.
I'm sorry, Chair, so you're not in making that that additional person, making the provision for the appointment of that additional person subject to your discretion? That's what you're saying?
I don't think we should go that route.
Okay. Well, then yes, it can be drafted to in the manner that you're suggesting. Yes.
All right. I have a saying: there's beauty in simplicity.
Okay.
So what would be what would be the 2 additional officers? The 2 additional appointees.
Well, I
The
don't.
Employers and then 1 other.
Right, but I don't even know if the 1 other need to be specified as such, but matters relating to labor relations, gender affairs, and we can find something else put in there just to round it off. Because there may be areas that we didn't even contemplate at this time.
But Chair, sorry, but when we were doing the counting, didn't we end up with 14? So we are actually leaving off a particular interest group now. That's what you're saying?
Let's see what
we had reached 13.
Or 13?
Yes.
Okay.
But I think we could just, you know, have a put something in there that would give the minister the flexibility in the appointment to think, because there may be an area that we have not thought about at this time.
That's why I thought it should have been included.
That's true, Minister, because given
I agree.
when you start hearing the matters,
yes,
you might decide somewhere along the line that there may be a skill set that is required.
That's right.
And this gives the minister the opportunity to plug that hole.
That's right.
That was the idea behind the suggestion, Minister, why I suggested that discretionary person be there, because we just can't think of it all the time.
So we just include it here and other matters that will relate to the work of the tribunal, rather than separating that 1 other and go to the Senate and have a fight. Right, Senator?
We'll fight for it.
We'll fight for it. You know me and
We will fight for it. Yes.
Defending the cause.
Yes. So I think we go to 14, and you know, I know our technical team, they will know how to frame this so that we have a catch-all that we can consider any other area that we have not focused on or discussed today.
Minister, my predisposition to the mental health, to the need of the mental health. So
no, that will be included. That
yes.
will be included. Yes.
So where were we now?
So, Mr.
Chair.
Yes, Mrs. Seeley Brown.
Before we move on, I wanted to bring us back to that clause that we were having, clause 15, where we were having a discussion on disclosure of interest in relation to a matter before the tribunal. I said that I would have done some research and see how I can assist. Yeah. Through you, I will just ask Ms. Grant for the next meeting if she can look at the public sector procurement regulations, regulation 36, which speaks to a duty to declare a personal relationship. I mean, the provisions will have to be tweaked if they are accepted to suit what I think Senator Gale was stating that he would have liked to see in the legislation. But just have a look at that, and if she can even do a copy and circulate it to members to see if something like that would work in relation to the concerns that were raised in paragraph 8 of clause 15.
Repeat for me, please.
It's the public sector procurement regulations, I think it's 2008. Yes, and it's regulation 36, which speaks to a duty to declare a personal relationship. I mean, it speaks to things like a conflict of interest, which is not what is necessary here, but just the style and the way in which it was crafted, and see if we can adopt similar provisions to deal with the concerns that would have been raised in relation to that paragraph.
You got that, Ms. Grant?
Yes, Minister.
Oh.
And just going back now to the areas that the skills we are looking for, we say employer to be included, mental health, labor, gender. We have mediators, we have attorneys, and any other area in
Chair, again, sorry to interrupt you again. So we're not going with the recommendation that was made by Member Rodriguez with respect to the Employees Federation. Was it Employees Federation?
Yes. Employers, yes, we are.
I haven't heard us mention it, Chair, in the 12.
Yes, she's employers, labor person,
mental
health,
gender, mediators who will not be attorneys. Right. And then any other, and you know, in capacity in any other matters relating to. And you will know what to give us a catch-all phrase. Okay, so are we agreed here? We agreed on where we are?
Sorry, excuse me.
Yes,
sorry. The employers would be represented on the tribunal, but not workers?
Labor, one would assume
labor.
that
the labor, are you want to say, would you prefer to say
but
worker?
I don't know what labor. I don't know what labor, you're right, because I don't know what.
Maybe we could use the term worker representatives.
Yes.
No, because this is talking about someone who has experience relating to labor relations. Doesn't mean it's
we're clarifying now.
Okay, sure.
Yeah, trade unionist or someone representing workers.
Right.
Okay.
So if you're going to have an employee representative, you have a worker representative.
Employer representative.
Employer or worker representative.
Mental health rep.
Gender.
A gender rep.
Is it a and or is a and?
And.
Okay.
And mediators not being attorneys.
And then in any other. People having had the experience of and shown capacity in any other matters relating to.
Where you cap the attorneys?
Or
no, where? In which one of the subclause you cap the attorneys? Because the employers will put in an attorney as the employer rep, you know.
No, it has to be an employer. That's why I suggested employer federation or PSOJ.
No, well, I don't think we should name an organization.
Right, just say an employer rep.
You know, we're not going to name the organization.
So,
but it has to be an employer.
So should we say an employer who is not an attorney?
That's why I was suggesting if we could cap attorneys up at attorneys.
So can we then, maybe we could put in a clause and a stand to be guided here, which says the tribunal should have no more than 4 attorneys, or is that too bright?
We have to cap that, Chair, through you, Chair, rather than just saying who are not attorneys, who are not attorneys. We can just cap it. We could just cap it.
Someone has to bat for. Somebody has to bat for attorneys, and I'm stepping up.
Yes.
I'm really stepping up because I want. What is the challenge with the employer being an attorney? Is there anything difficult? Is there something that is all so negative?
No, don't read it like that.
Attorney who is an employer.
Don't read it like that. Don't read it like that. Let me explain to you.
Wait a minute, Senator Gale. Since I made the suggestion, let me go to the wiki. Since I made
please allow me to finish. Allow me to finish, and then I invite you to all comment.
One moment, please, MP Siblings. We're going to get some order here virtually. All right. MP Siblings, will you please go ahead now? MP Siblings?
Thank you. Thank you, Chair.
Thank you.
What I'm saying is that I am okay if any category is capped. Reason for capping a skill set, if that skill set, why should we have two psychiatrists or one, or why should we limit it? Because you might have a psychiatrist who is also an attorney at law. I wear many hats, right? I'm an attorney, I'm a chartered accountant, etc., etc. And if you begin to go there, you might have a difficulty even where you're asking an organization to a worker or an employer representative. So I am not, once again, I have no difficulty in having the number of a particular skill set being capped, but I just not understanding why is there a reason? And I would have to come out and ask, because of course I am also a member of the Jamaica Bar Association, and I could not sit here and not get that out so that it could.
Thank you, MP Siblings.
May I respond?
Campbell Rodriguez?
Yes, since I raised the issue, I want to clarify. It is not anti-attorney. It is, we already have 4. And if you're looking for a representative who is going to represent employers, for example, you want someone where that is their substantive job, that is their substantive work. So we don't have huge law firms in Jamaica, for example, that necessarily hires 50, 60 persons and understand labor issues from the perspective of. So if you put a lawyer for the employer's representative, that person is typically going to be thinking as a lawyer, not as an employer, because they don't deal with employer-employee issues on a daily basis. So I'm not sure if MP siblings heard. So I just think you have to be careful that you don't flood one tribunal with one main profession. It is not a legal issue per se. This is something where you have to have someone who comes in and represents different perspectives versus just one profession flooding it.
Chair, may I?
Thank you so much, Senator. So,
Chair, may I?
Yes, please go ahead. Yes.
This was never meant. My response was never meant as an attack on the legal profession. We already agreed that we would have sought to cap the number of attorneys, and the attorneys were placed into the particular jurisdiction to where they would represent as chair. Now, the other areas apart from the mediators are specific skills so defined. And what I was guarding against is a situation where you have someone representing the employer that would bring to the table an understanding of employer issues, planning, directions, leadership in the confines of employment. And we so want to ensure that the composition of the tribunal brings that type of expertise in understanding the issues in relation to how an employer, any representation the employer would see it. And the second point is that once you have a worker representative on the one hand, you also want to strike that balance and compromise with an employer representative. So it was never meant to develop a blockade against attorneys. And I want that to be very, very clear.
Senator Gale, MP Siblings, Senator Gale, and
Yes, Chair.
reflecting the opinion of all the members.
Yes, Chair.
You know, there is no prejudice against attorneys. You know, and usually the work of the attorneys are
I accept
standing,
what Senator Gale is saying.
maybe Senator Rodriguez felt that the attorneys will be so convincing right, because of the skills they have. But at this point, I would ask that members should indicate if we can conclude that we're increasing the numbers to 14, and we can indicate, and I would like Mr. Sibley's opinion on this, if we cap we do a cap as was suggested earlier in relation to the attorneys here, that the cap 4 and 4 for the certified mediators. So MP Sibley's, what's your opinion?
I couldn't agree with that, Chair. And I couldn't agree with capping any of the skill set per se, because as I said, we are living in 2021. Many persons who happen to be attorney at law, but has other said. And in light of what Senator Gale has said earlier, is what you're bringing to make sure the constituent, whether it's the constituent of the employer perspective or the constituent of the worker perspective, or the constituent of the gender base. And you can have persons with shared skill set in those areas. Mediation is an area where you have of mediators who are attorneys and do practice mediation more than their skills of being attorneys. And so I would not feel comfortable, because we would want eyes on those skills of being mediators. So you have some excellent mediators who are attorneys who don't really practice do much attorney work. But everyone who know these mediators want them to be a part, to be their mediator, because they want to come. But they happen to be attorneys at law. So I on that basis, I could not.
All right. I will ask the members. Yeah, you share the position of MP Sibley's that we do not cap any profession or expertise that is listed here in the legislation. Senator
Chair,
Gale.
can I suggest that at this point of the evening, we conclude on that matter? We consider it until the next time we deliberate. Maybe at that point in time, my colleague in his lovely green background may reconsider his position.
You know, you preempted me, Senator Gale, because it is now 5 minutes after 6, and we had booked the time for this meeting from 2 to 6 p.m. So we're just in time to take the break. We've had an excellent session like we did yesterday. And I think at this point, I will ask Ms. Grant to summarize what is her understanding in relation to clause 15. I'm sorry, in relation to clause 17, is it, Ms. Grant? What clause we're now?
Well, the discussion recently concluded really was surrounding clause 11.
Yes. So we will come back. Well, let us agree on certain things in clause 11. We have agreed we're increasing the number to 14. We all agreed there, right? And we agree on the skill sets that we would wish. Could you summarize what the skill sets are, Ms. Grant?
Mental health, labor, gender, employer to representative, and the worker representative, mediators. That's a skill set that we agreed on.
Right, and attorneys.
Yes, and attorneys.
Right. Okay, so we agree on those skill sets. We'll have a catch-all phrase that would determine any other skill that would be relevant in this regard. And then we will go back to that at another time to see if we would wish to introduce a cap on skill sets. Am I correct? Is that the understanding?
Yes, Minister.
Yes,
All
Minister.
right, good. So now we go now to the clause where you had reached, and you said that was clause, remind me,
16.
clause 15, clause 15?
16.
16.
Because we're to come back to 15.
Okay, fine. So you are going to work on what Mrs. Celia Brown has said. She will provide you with information, and when we come back, we will look at, we will take a second look at clause 15. Am I right?
Minister. Yes.
All right. And so we have come to the point where I think we have done quite a bit of work like we did yesterday, and that you all deserve to go and have a really great dinner.
Thank you, Minister. It's at this point we worry about our brain getting a sprain.
That's right, that's right. Yes, here the mental health expert telling us it's time to take a break. And so I want to just thank you all, the technical team, Solicitor General, everyone here, members of the committee, and the media that has been listening in on our deliberations. And to thank Ms. McCarthy, our coordinator. Thank you all. Will someone so move?
Minister, sorry, are we going to set a date for the next meeting? Next week is not possible.
Well, we have a couple of dates that could be proposed. Wednesday, March 10. And what's the other date, Ms. Mack?
The 17th, Wednesday, another Wednesday at 2, because we have budget debates set up, as well as the Planning Finance Committee. We would have to set up in between that, since MPs would be unavailable.
So would members agree that we set the 10th and the 17th?
Just to interrupt, I think some of us will have another joint select committee meeting on that day. The tobacco. Some of us from this team, the technical team, may have another joint select committee meeting on that day. The tobacco.
17th.
That's a bad day.
Yes.
The 10th is a bad day.
So we can work with the 17th?
Yes, for me, yes.
Everyone?
Sorry, that's the 17th?
Yes.
17th of March?
Yes, it is.
Yes, I think that's good for me.
All right, so we will confirm the 17th of March. We will again do a virtual session, and we will conclude the revision of the various recommendations made in the matrix.
And that would be at 2 p.m., I assume?
It will be at 2 p.m. It seems to work for all of us. Am I right?
Okay. Minister,
yes,
would you also want to cap the 24th just in case, to get people tied down to the 24th? Just in case, because I don't think we've gone over the definitions as yet, or the general recommendations.
So you'd say the 17th and the 24th?
Yes, just to ensure that we have enough time.
Did you say 23 or 24?
24. A Wednesday.
Okay.
Agreed.
All right. Agreed.
Okay.
All right. So we are really moving expeditiously on preparing the report, so that after the main debate, or even during